only prescription. It's more cowbell.
Oh boy. All right, so here we go. So this was today, and God, this was ridiculous. So let me bring this up real quick while we're sitting here, because I'm doing this quickly. So what we've got today, let me do it this way, and Dexter's being a clown. There's a gigantic dog in my office. So if my camera randomly starts moving, it's because he's being an idiot. We also have any super chats. Super chats of 20 or more will get him a genuine cow kneecap. That's him in the background. And any other super chat member will get a treat, KTZ style. Now, this took place earlier today. If you see, it's labeled 355. I wanted to make a bunch of videos today, but instead of making a bunch of videos today, I screen recorded this. It took literally 3 hours and 55 minutes because they kept having to break to go look at phones and all sorts of nonsense. So now he's smelling all of my shoes. But yeah, it took 3 hours and 55 minutes. We're going to watch it at 1.25 speed. Every once in a while, once they, get off the record, handle other cases, I'm going to skip it. I didn't have time to edit it because then I would have to watch 3 hours and 55 minutes, and ain't nobody got time for that. So once it hits a point where they're off screen, I'm just going to skip ahead and we'll find it where we're finding. K-Far's over here just abusing his dogs. Yeah, I even got regular sized dog treats because he's a gigantic dog. There will be a camera set up somewhere for him to eat all of these treats, but until then, we're just going to wing it. Again, bear with me. This is long for no reason. You're just looking for the grossest things to feed that dog. KTZ had, what was it? Chicken feet, duck feet, something like that. I was just looking at random dog treats on DoorDash before one of my streams, and I'm like, cow kneecaps? That's the craziest thing I've seen, so I got them sent to the house. Anywho, there's 32 people here. Buckle up. This is going to be long, long, long. And just so you know, before this case has been, this is part 3 or 4 already. There is a new attorney in the house. And if you watched my last stream, just pick you guys up where we left off there. The attorney in blue at the bottom of the screen, she said she had anxiety. So it seems as if the other legal team brought in a super pushy female attorney so that she would mess with the girl's anxiety and she couldn't claim like she did last time, oh, he's intimidating me, he's being too forceful. And she plays just a giant mind fuck on this attorney, and I love it because she genuinely tried to use anxiety as a reason why she should just get away with whatever she wanted. They should be called moo caps. Yes, I love the name moo caps. Here we go, guys. Let me know if the volume's good. Like I said, I screen recorded this over the whole morning today.
All right, and so the court is going on the record in the matter of William Branson versus Heather Collins, 2402269, and appearance for Mr. Branson.
Good morning, Your Honor. Amy P. 0461 on behalf of Mr. Branson.
Okay, I'm sorry, what did you say your name was, counsel?
Amy Ducray.
Ducray, okay, I didn't hear the last name, I just heard Amy, okay. All right, and
Good morning,
I did receive your appearance as co-counsel, and I'm sorry, counsel, your appearance.
Good morning, Judge. I'll leave that repair also on behalf of Mr. Branson. Your Honor, I asked Ms. Ducray to come in because before she became a lawyer, she was a elementary school teacher and has got a lot of experience with.
Okay, hold on, we'll get to that in just a moment. I'm just putting everything on the record.
Yes.
All right, and Mr. Branson?
Good morning, Your Honor.
Your name for the record, please.
William Branson.
Okay, good morning. Okay, and counsel?
Good morning, Your Honor. This is Megan Dagala. I appear on behalf of the defendant, Heather Collins, today.
Okay, thank you. Good morning, and your name, please, ma'am, for the record.
Heather Collins.
Okay, thank you. Okay, so today is the adjourned date for the parties to return. The issues that are, there's a couple things that we are hoping to resolve today. One is the escrowed monies. The other are utilities. And then there are some allegations as well regarding mail as well. The defendant had filed a motion to dismiss. Ms. Collins did improper prior to Ms. Declala submitting her appearance. And let's handle the issue of the, we're also going to address the issue of the order regarding the inspection. I reviewed the order. I'm not going to sign it as written because this court did not order paragraph 2 that was added into the order. There's recourse, but I'm not, I did state in there regarding any interference or third party, so I'm submitted. So that would have to be removed before the court signs it.
Your Honor, can we do that now and resubmit it to you?
What?
We'll do it now and resubmit it to you. Ashley's listening, she's still on this, I mean.
Okay, that's fine. I'm just saying that, I mean, that's fine, we can just submit it. I'm just not signing it as currently submitted. The court is also going to address the issue of the I don't want to call it inspection, but I don't know what I want to call it. Well, Mr. Branson's ability to look at the property as far as what maybe needed to be done or why not. So that was on the 10th, so we'll address that as well. Okay, so there is an allegation that Mr. Branson cannot proceed because he does not have a valid CFO. Ms. Collins, in her motion, references a specific paragraph that would not allow Mr. Branson to continue.
Okay, so to talk about this real quick, because I put it in the last 2 thumbnails for this, in the original hearing, they were going back and forth about how the landlord, in this case, knew the judge, knew the cops, yada, yada. That's what the tenant said. And then the tenant right at the end made a claim of the landlord knew the judge from being swingers or something of that nature. And Judge DeSanto just lost it and started laughing, which I thought she was going to get rude about it, but she just started laughing. Everybody laughed. Everybody had a good time except for the tenant, who's just epically behind the 8 ball on this case. But that's where the upside down pineapples came from.
Now, item states that this residential property was kept for the use intended, has been kept in reasonable repair during the term of the lease or license, and is in compliance with the applicable state and local health and safety laws. Okay. Any defects in the statement must be explained below. And then it says the disrepair or violation was caused by the tenant's willful or irresponsible conduct or lack of control. So counsel, I understand that your client filed this, but you also did indicate at the last hearing on Tuesday that you were relying upon the motion. And so what part of that would require this court to dismiss this action?
Okay. Your Honor, this action must be dismissed under MCL 125.530. That is the Michigan law that requires a certificate of compliance to be held by a landlord. Under paragraph 5, it states that an action may be maintained where there is not payment into an escrow account. So,
Sorry, what was that? An action what?
May be maintained, an action to recover possession of the premises may be maintained where there's not payment into an escrow account. My client has been paying into the court's escrow. I have the register of actions here.
So this isn't the first time. Well, this is the first time, but it's not the last time that this attorney tries to use this talking point over the next 4 hours. She tries this multiple times, even at the very end. After the judge denies it every single time, she'll still try it at the end.
Yes, this court signed an order of escrow.
Correct, and she is in complete compliance with that. On January 21st, She paid $4,000 into the escrow account as ordered on January 31st. She paid her monthly rental amount in the amount of $1,500. Of course.
Just one moment.
Sure.
So you're relying on MCL 125.530, paragraph 3, which you said paragraph 5.
I did say paragraph 5. I'm actually relying on the entire, all the provisions of 125.530.
Okay, so just one moment, please.
Yeah.
So council, you have 125.530 pulled up?
Yeah, yes, Your Honor.
Okay. Okay, so I believe that 125.530 would speak specifically to the issue as to where the monies go from the escrow account.
Your Honor, if I may.
Just one moment, please. Right now I'm addressing the motion to dismiss portion of it, not the portion that we're going to address regarding the payment of the escrow account. So as to the motion to dismiss, Ms. Klala, what in paragraph 7 would support the request to dismiss this action?
Okay. So I'm referencing 125.530. Generally, this was brought up in the defensive responsive pleading and it was relied on quite heavily. It's actually stating that the property can't be legally rented out when it doesn't have a certificate of compliance. You know, that's pretty obvious to us. The issue here is whether an action in eviction can be maintained in a local district court where there is not a valid certificate of compliance. There's certainly not a valid certificate of compliance in this case. We're all aware of that. There's an inspection scheduled with the city in order to correct for that. In particular, I'd like to draw your attention to the court rule for these proceedings. In particular, I'm referencing MCR 4.201 B3C.
Okay, let me pull that up.
Again, that's MCR 4.201 B3C. I'll go ahead and read it.
Just one moment.
Sure.
Complaint specific requirements, 3C. If the tenancy is of residential premises, the complaint must allege the lessor or licensor has performed his or her covenants to keep the premises fit for the use intended in reasonable repair during the term of the lease or license and in compliance with applicable state and local health and safety laws, except when the disrepair or violation has been caused by the tenant's willful or irresponsible conduct or lack of conduct, or the parties to the lease or license have modified those obligations. Yes.
Gregory, that's really the reason I started covering this, because the logic is so, I don't want to say like sovereign citizen like, but she's basically trying to make the point that, here, I'll put it up so everybody can read it. She's basically trying to say, well, this ordinance from the city says this, even though I signed a contract and I've been paying for X amount of time, he can't evict me because this ordinance says I shouldn't have been there in the first place, but I'm there now. And it says they can't collect rent, but I'm there now. And it's just like, so you don't have to pay rent. They can't evict you. You don't like where you're living. Like, why can't you leave? And then anytime they try to get the occupancy certificate, she throws a fit about it. Like in the last hearing, they were supposed to go there, him and another person and her and another person, take photos of things and call it a day. Well, he decided, you know what? I'm going to forego a person that I know. I'm going to call the police. Have the police be there just in case anything goes crazy. They're already there. And she flipped shit, and she's going to flip shit again.
Provided for by statute. Plaintiff must explain any defects in this allegation. For example, local government's failure to inspect despite a request to do so. The relevant scale form must provide space for this explanation. The court may not refuse a filing based on anything in this sub-rule. Okay?
Okay.
So you're relying on the part stating that the plaintiff is not in compliance with applicable state and local health and safety laws?
Correct. And
Okay. So what local health and safety laws are not in compliance?
okay, that would be the City of Wyandotte Ordinance 181.020. No,
Sorry, 181.
0.020.
Okay.
No person shall lease, rent, or cause to be occupied a rental dwelling or rental unit unless there's a valid certificate of compliance.
Okay. So does that fall under state and local health and safety law?
Yes, it does.
Okay. How does that fall under there? Because that seems to me to be an ordinance that the city can then enforce against Mr. Branson.
Absolutely, Your Honor. But you know, that's exactly to my point. It's something that the city can enforce, and this is meant to protect the safety of its citizens who are renting out residential units. So it's in direct conflict with the court rule that requires when you file a complaint in these matters for the landlord to represent that the residential property is being kept fit for the intended use.
Okay, so what's in direct conflict, counsel?
Okay, what's in direct conflict is that the certificate of compliance is required to assure the health and safety of the citizen living in the unit. So in order to file a complaint and represent that it was kept fit for residential use, not only is it required under local law for the city of Wyandotte under section 181.02, but also under the court rule for filing these actions, the complaint must allege that the premises is kept fit for the intended use and it's in reasonable repair. So as you mentioned, then it goes on to state in compliance with applicable state and local health and safety laws. Certainly 181.020 is a local ordinance that's protecting the safety and health of its citizens. That is a local ordinance that's meant to do that.
Okay, and your response, counsel?
Your Honor, my response is severalfold. First of all, the applicable MCR 4.201 sub B, sub 3, sub C clearly states in its express language that this matter cannot be dismissed for a defect of this section. It says that, it's the last line in here. The court shall not refuse to proceed pleading because this is not complied with. So even if there is a defect in the way that he pled this pleading, that doesn't mean that it should be denied.
Okay, it reads a court may not refuse a filing based on anything in the sub rule. So the court has to accept.
And this attorney that is now speaking for the landlord, she is new. She was not here in the last cases, and she is just the kryptonite for the tenant's attorney. Everything that the tenant's attorney is afraid of or triggers her anxiety, this attorney is. And because she's also a female, she can't claim all the things she claimed about the male attorney.
Accept the filing. Okay, so the fact the court has to accept the filing doesn't mean that it cannot be used as a basis to dismiss the matter, but I just wanted to clarify that.
Yes. So that defect is not a fatal defect as sister counsel claims on the face of the pleadings. That's my argument, Your Honor. Second of all,
I'm sorry. So the defect that your client does not have a certificate of compliance or certificate of occupancy, whichever the title is. I think that it was changed at some point. And so you're stating that that is not a violation of the third part being in compliance with applicable state and local laws?
it's not a local health and safety law, Your Honor.
Okay.
This is a municipal code under the building code. And if you read section 181.001, where it talks about the certificate of compliance and the purpose of it, a certificate of compliance is issued by the Department of Engineering and Building, which certifies compliance with provisions of codes and ordinances of the city for all rental and dwelling units. There's no mention anywhere in the statute that this should be applied as a health and safety standard. And without actual case law or some citation or some legislative, quasi-legislative intent of the body who enacted this, it doesn't fall within the health and safety laws of the city or the state of Michigan. Moreover, there is a direct statute on point, Your Honor. And that direct statute is a statute that Ms. Zavala was talking about first. And if we go provision by provision through this statute, Your Honor, you can see that their argument is completely erroneous with the plain language of the statute. And we're talking about section 1.25.530. And if you talk about subsection 5, for instance, it is clear that it says when a certificate of compliance has been suspended or has not been issued and the rentals thereafter withheld are not paid into an escrow account, meaning Ms. Zavala and defendant are looking at the wrong time period. The defendant did not put monies into an escrow account until she got involved with this court proceeding. She had provided zero evidence or zero proof that there was any escrow account. Moreover, if you continue to read that provision, Your Honor, it says that the escrow account must be managed by the authority with the department with the authority to oversee compliance with the certificate of occupancy, meaning that the defendant would have had to place, at the time she withheld those rents, at the time she decided, I'm going to withhold the rents because you don't have a certificate of compliance, she would have had to place those monies in escrow with the building department of the city of Wyandotte.
So yes and no. They keep alluding to like, oh, this is wrong. This is wrong. But then when they go to show pictures, it's like, oh, no, I forgot that one. Trust me, bro. Instead of like actually showing what's clearly wrong. And they get into it. Spoiler alert. They'll get into it later. She brought like 2 boxes of pictures and text messages and shit. But they were like perfectly curated text messages that were completely out of context. And the landlord brought his phone and it's just like, yeah, that's not what it says. I can prove it. And then keeps proving it. So yeah, it's a lot of Chris Ryder, trust me, bro type shit. Let's see here. And yeah, the other attorney could 1000% kick her ass. I want to give credit where credit's due. Somebody in Law Talk with Mike's chat, I was screen recording this in my office, and I was in my kitchen watching the Law Talk with Mike coverage of this on my security camera, like monitor thing in my kitchen. And one of them said, instead of Perry Mason, this attorney is Periwinkle Mason, and she's not very good. So shout out to whoever said that from Law Talk with Mike's chat, because it was perfect.
And she didn't do that. So she's not in compliance with the statute. And when at the time that this provision was filed, so her complaint now that there's a defect on the pleading, that it falls outside the scope of the court rule and that it falls outside the scope of this provision is erroneous. Because even if you look specifically at the other provision that Ms. Duckwalla stated, which is 1.25530 subsection 3, it says that the duty of to pay rent is suspended, but the monies have to be paid into an escrow account. So defendant comes in here with unclean hands, Your Honor. She comes in here having withheld rent. And the first time she made a complaint is after these proceedings of eviction have started. And it was only after the order of this court that she put her monies in escrow. She cannot now come into this court with unclean hands and try to fix what she did wrong because this court ordered her to do something that she should have done from the beginning. Plaintiff is within his right to bring this action.
Okay.
May I respond?
Just a moment. Okay, so as it relates to not having a certificate of compliance filed with the city, I don't find that the remedy for that is to dismiss this action. So on that point, I'm going to deny the motion. You also allege the property was not kept for tenants' peace and enjoyment required by law. And then also that it was not kept fit for the use intended. And never did finish the kitchen update. So I can't rule on that without taking testimony regarding the intended, whether or not it's been kept kept fit for the use intended. And whether or not it was kept for your client's peace and enjoyment. So I can't rule on that portion of the motion until I take testimony on those matters. So,
Okay, so this is my question for this. So if the landlord if this got dismissed because the landlord didn't have a certificate of occupancy, does that now make her a trespasser or a burglar in the home since she's not supposed to be there? Because, like, is she now a squatter? Because in my head, if you're not supposed to be there, or if they're not supposed to be there, then the landlord could theoretically just grab them and Uncle Phil them out the door at their leisure.
okay. Now, counsel, your client has stated that the property was not kept fit for the use intended. For example, a bug problem. Okay, so I'm going to swear in Ms. Collins and Mr. Branson. If you can both please rise and raise your hand. Do you both solemnly swear or affirm the testimony about to give this matter be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Yes, Your Honor.
All right, thank you. So, Ms. Collins, or counsel, Ms. Duckwalla, your clients raised the issue that the property was not kept fit for its intended use. Okay? She cites, for example, a bug problem. I'm not sure if there was any other problems. Okay, not finishing the kitchen. So other than those two issues, are there any other matters that your client is alleging where the property is not kept fit for its intended use?
May I allow her to speak on it?
Well, first I'm asking you, counsel.
Okay. There's a mold issue in the basement causing significant health issues.
Mold.
Hold on just one moment.
Mold issue.
All right, so you're alleging it's causing significant health issues.
There's a mold issue and a bug issue, and 3 hours from now, they go into that further.
My client is asking if she can sit down. She's not feeling well.
Okay,
Thank you.
all right, so let's talk about this. All right, so you're alleging a mold issue in the basement causing significant health issues, a bug problem. The kitchen was not finished.
There is a window in the basement that is almost fully detached from the front wall, allowing, a lot of environmental issues like wind, water, rain.
Hold on, let's see, window and basement, almost fully detached.
And if a window in the basement was completely or partially detached from the basement wall, A, why would you move in there? And B, why would you not be calling the city daily until your landlord came and fixed it? Also, why wouldn't you have a picture of it blown up on a 24 by 36 fucking cardboard poster that you could be like, yes, Judge, this is what I'm talking about. But she doesn't have that.
On the wall?
Yes.
Okay. Okay, what else?
I would like her to continue if it's okay.
Well, counsel, I'm asking you because you're representing her, so I'm asking you right now. So what else?
The basement floods, separate from the window issue.
Floods.
There are certain fixtures within the house, such as vents, that are completely detached from the wall.
Okay, I'm sorry. Fixtures
Yes,
attached from the wall.
yes.
And you said such as vents. Anything else or only vents?
Yeah, like I hate to keep stopping it, but like in my head, it's really that easy. If you want to make complaints to the city, you have mold, you have pictures of mold and pictures of a detached window from the wall. Send that to the city. They will condemn the house and it'll get fixed. Or they'll just burn the house down and call it a day. That's the thing, Katie said. It's a whole ass house. And she says, this is where it gets confusing because sometimes she's like, yeah, I'm trying to leave, but I don't have money. But then the other times when they try to like figure out how to get her money so she can leave, oh, but this is wrong, so I can't be evicted. And it's like, which is it? Do you want to stay here forever with the mold and the bugs and the detached window, or do you want to move? Like, which is it? You smell bullshit? You might be onto something.
There are filters that are broken.
Counsel, I'm still on the fixtures attached from the wall. Is it only vents? Is there something else that is attached from the wall?
I'm not sure.
Okay. Ms. Collins, yes or no? Is there anything in addition to vents that are detached from the wall?
There is.
No, yes or no?
Yes.
Okay. What else is detached from the wall?
There is, off the flooring, off the back rail of the steps, there's a metal plate that comes right off. You can just pick it up and fall right through.
Is that the wall or the floor?
The floor, excuse me.
Okay, so I asked about the wall.
The vents, all the
Is there
vents.
anything other than the vents that you're alleging are detached from the wall?
No.
Okay. All right. Mr. Clown, you may continue.
The windows in the basement.
That's already been addressed.
I suppose there may be more than one window with maintenance issues. There is one main window that is almost completely detached from the front.
Okay.
The vents don't close?
Some don't. One room has no heat or air.
Okay.
There is one room with no heat or air conditioning.
Which room is that?
My mother's room. The front,
I'm not sure.
it's my mother's room. The one used for my mom.
Okay, I don't know what that
Is
was.
it
First floor, upstairs, where is it?
Upstairs, very front.
Is there only one room in the upstairs front?
Yes.
Okay.
I'm not sure that's an exhaustive list, but that's what I'm aware of.
Okay. Did you send any of this communication over to Mr. Branson's attorney before today?
There have been,
There's also more than just that, yes.
Hold on, ma'am.
there have been,
And see, that's the problem with this is they've tried to get it several times and she won't let them in. Kind of not so spoiler alert because they did this last hearing. They actually have a inspector coming on Wednesday of next week to get the certificate, and she's already bitching about them coming. So it's not that they haven't tried, it's that the tenant is intentionally setting every trap, every booby trap, putting up a blockade for them to do anything.
many exhibits filed, but the problem is that I have,
So that wasn't my question, counsel.
Mhm.
My question is, did you specify these concerns, the ones that you just stated, I understand it may not be an exhaustive list. Did you specify these concerns with Mr. Branson's attorney? Yes or no?
I did not.
Okay, so counsel, let's, actually, Mr. Cloud, what's the bug problem? Your client alleges in the motion a bug problem.
Yes, she's having to shower with swimsuits on. The bugs are so intense in her shower. I filed quite a bit of exhibits. Contained within those, there's text message evidence that she's asked her landlord several times to fix the bug issue.
Okay, which page of the exhibits are we referencing on that one?
Okay, one second. Your Honor, respectfully, I have a time limitation today. If we're gonna have a full evidentiary hearing, is there any chance to be able to prepare for that? Come back or no?
She's on a time constraint, yet this took 3 hours and 55 minutes. Yeah, she's basically pulling a Kevin McAllister on them. Anytime they try to get something, she's there to stop them. Because if they got a certificate, it would only hinder her argument.
There's a lot of exhibits.
This is your client's motion to dismiss, so.
Motion to dismiss, yes.
Right, but one of the
Okay.
elements of that is that your client claimed that it was not kept fit for habitability.
Okay.
So I'm trying to, like I said, I couldn't, make a ruling on that until I took testimony. So
May
that's what I'm doing.
I don't have a specific page number, but these were filed, and that was on Tuesday. May I approach the bench with,
What was filed on Tuesday?
these are text messages.
On Tuesday those were filed?
Yes.
I think that, okay, let me, is there a date on those text messages?
Yes.
Okay, what's the date?
It's June, July, and August.
June, July, and August, okay.
Your Honor, it's the 102nd page of the document that you filed at 8:03 in the morning on Tuesday, just before the last hearing. Page 102, Your Honor.
Okay, I'm not sure if I have that.
There's no base step on there, Your Honor, so that's the problem, that's part of the problem.
Well, let me see. So I'm showing, what I have here is January 31st, and our landlord tenant clerk has unfortunately been out ill. So it's page, okay, but I need to check to see if Carly can grab that off and because I don't see it in my let me see here. I'm not showing anything here.
Your Honor, it isn't actually, there is a date stamp, there is a document that is, like, we have it, it says that it was filed with the court on 2/18/2025. And if I could assist sister counsel, the text message is in that document. So if that's the document that you have, you might have the text message that she's speaking of, and it is on around the 100th page.
I have January 31st, I have a date stamp thing, I don't have that one, so if you, I'll take, let me just take let me go off the record for a moment, let me check these people in here, and then let me go jump off and grab that to be printed. Just one moment. In the meantime, Ms. Watson, we're gonna try to figure out who's here for Mr. Landau.
Okay, thank you.
Okay, Attorney Francis, good morning, which matter are you here on?
Good morning. I am here.
Okay, so let me take this off screen real quick because they did push on to something else. Dexter's just chilling over here. But yeah, they do, like I said, they eventually kick out to other cases because this isn't the only case. but it's always to like find dumb shit. Like, you know what? I'll show you. I'll keep it on screen as I do this, just so you guys can see what I'm talking about. Like this right here, the judge isn't even in the for some of this stuff. Come on, bring it up. There we go. Like, yeah, she's trying to find paperwork or trying to find fucking pictures and text messages. Judge isn't even there. Judge is like, I'm out, deuces, see you when I see you. And like I said, this is why it took 3 hours and 55 minutes. Because shit like this kept happening where they kept losing paperwork or the paperwork was in the wrong order. Like right now, judges hasn't been in the courtroom for 10 minutes. I guess she had to go on a swingers break or some shit.
Okay, and that's another Zoom, or is that in person?
Okay, that's another case. That's another case.
Voir dire some to try to figure out what it is.
Let's go back.
Yes, June, July, and August. It's Exhibit 5 in terms of the bugs in particular.
Exhibits are continuing.
This case by January 31st.
Okay, before we get into this again, the good broken system, broken trust, everyone. For $2, it's ladies' night tonight, and I'm buying. So as you guys know, my cool co-host, he's here to eat treats and then immediately get off camera because for some reason, yeah, he's just anti-cool kid stuff today. There we go. And yes, I have red carpet in my office. Why? God only knows. God only knows. And it's back off until the next one. Back to this nonsense. Okay, here we go.
And they, on the eve of the last court hearing, produced 105 pages of documents that are not marked. Second of all, if you look through a substantial number of these documents, they reference text messages, which are not the full record of the text message, and they bear no date or time as to when they were sent.
Okay, so let me take those one by one. One, the court's going to still allow the exhibits to be submitted because counsel filed her appearance and appeared in these matters after January 31st. So I'm going to give leave for these exhibits to be admitted. Just as though, and there's also been adjourned court dates as well. So as there are other matters that are brought to the attention and exhibits are continuing to be submitted to court, so it's kind of more of a fluid type thing. As the text messages, the objection is noted. I'm going to see if I can voir dire some to try to figure out what it is or not. Where you're talking about the June, July, and August?
Yes, June, July, and August. It's Exhibit 5 in terms of the bugs in particular.
Exhibit 5. Okay, Exhibit 5. So let's go to Exhibit 5. The first one I have is dated Sunday, July 14th at 10:57 a.m.
The first under Exhibit 5 that I filed is from Friday, August 2nd.
August 2nd, why would it not start with July 14th?
They are in reverse order.
Okay, well, we're gonna start with Sunday, July 14th, because I would presume that that's the way we need to start. So, the first one says, sorry to text so early, those bugs are back in the tub, I seen them yesterday sprayed, what I have them, they're still there today, these things don't want to die. What type of bugs are we talking about?
Your Honor, there is a page before that.
Oh, okay, well, okay, that shows August 2nd, I didn't realize that would be attached to Exhibit 5, I thought, I missed that part, I thought it was only the title, Exhibit 5. All right, well, I'm not going to review August 2nd until at that date.
That's, so Exhibit 5 is actually in reverse order. So the last page, it starts June 18th, and then the one where it says Exhibit 5 is in August. It's the last communication. I do apologize
June 18th.
to the organization.
Okay, well, the back of Exhibit 5 for me is September, I don't know, I mean, is there an Exhibit 6?
Yes.
Oh, there's Exhibit 6, so maybe that's Exhibit 6. Let me see. Yep, that's exhibit 6. So, council, just for future reference, the exhibit page should not have any exhibits with it.
Okay.
So, okay. All right, so going backwards, Tuesday, June 18th.
Correct.
Count at 3:43 p.m. Does everybody have that one?
Yes.
And, council, if you don't mind if I just call you attorney Amy, that's a little bit easier to say.
I would prefer that, thank
Okay,
you.
thank you.
My last name is significantly difficult. It's very French for literally no reason at all.
Okay,
I'm trying to get to where you are because I think that when I was going through these, I may have shuffled them around. But no, I think I
I'm muted. That's my bad. All right, you guys got one. I guess we're doing this already. Here you go, Dex. There you go, my dude. So basically, it's not that the texts were out of order. It's that the text messages are incomplete. If we're going to think of it as a YouTube comment, where you have the initial comment and then you have everything underneath it replying to that comment. I'm already like 30 seconds ahead of you guys. So she provided the first text message, but none of the corresponding text messages about the replies to that. And that's what the judge is like, okay, that's not correct. And that's what the landlord's attorney's like, they're incomplete, so they don't count.
okay, you said Tuesday, June 18th at 3:43?
3:43.
Yes, you're right.
Yes, all right. Also, if you could look, and I'm presuming that the dark background with the light writing, the light writing is from Ms. Collins, correct? Okay. And then the white background with the dark writing is from Mr. Branson, correct?
Yes.
Look at these little black spiders. I have all in the bathtub and the bathroom when you're here. Mr. Branson's response. Oh, no. Okay, then there's not anything until Thursday, June 27th at 7:49 p.m. Okay, was there any communication between the two of you regarding these bugs after June 18th?
Certainly. Yes, ma'am.
Okay, where are those?
I don't know, but we could certainly.
It was just, yeah.
Well, first, if you're asking this court to accept these exhibits, why am I getting partial conversations?
He asked me to take care of them myself.
Okay, that's not my question. Counsel, you've submitted these as exhibit. So this court can view the communication between the parties
Right.
regarding the bugs, and these are an incomplete
Actually,
transcript, so to say, of the text messages.
I don't. He might have not actually responded.
You might just put your phone away unless the judge asks you.
Was there additional communication after June 18th and before June 27th regarding the bugs?
I can't recall.
Mr. Branson?
Yes, ma'am.
Okay. Do you have those on your phone?
My phone is in the vehicle because of the situation that's been going on with the phone.
Okay, so that wasn't my question, sir.
Oh, I'm sorry.
Do
No.
you have them on your phone?
Yes, ma'am.
Your Honor, I'm sorry, I don't mean to interrupt you. I think our administrative assistant has them and she can put them on the screen for you if you'd like.
I object. I need to be able to review exhibits in advance.
Well, counsel, you've offered the text messages between your client and Mr. Branson as a way for this court to determine whether or not there's an issue of habitability and the property was kept fit for living, and I have partial conversation here. So I need to have the full conversation. So this is new for everybody because, well, your client has everything printed up. Or do you have those printed up, ma'am?
I'm going to look at them in here. They're in this file.
Your Honor, she has them and she
Okay,
did.
counsel,
They might not be in this file.
we're not gonna have any communication right now until we see if these are in here.
Yes, Gregory, you keep having the greatest statements. She offered false evidence and now wants time to prepare for the actual evidence. The bug thing comes into play again in 3 hours. and I don't want to spoil it, but it's literally that bad, where she made the text message and the next replies from him were like perfect responses to what is happening with her in this house. And they don't want to show that because it hurts their narrative. And now that they're like, yeah, of course I have my phone, but it's out in the car. He has all these messages and they're worried about what it'll do. And if you guys just, again, for filling you in with what happened before, she was caught recording in the first part. In the next part, the attorney showed up without the tenant, but brought an assistant to carry her shit. The assistant was accused of recording. And when the judge was like, okay, cool, well, I now have your phone until after this, the assistant like ran up and was like, you're not having my phone, blah, 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 throwing a fucking hissy fit. So good on the landlord for like, nope, I didn't want any smoke, so I left that shit in the car. Also, we have a Dexter
I'm just gonna
cam.
stand up because my back hurts. I apologize.
That's fine.
I said 2 months. Painful.
Your Honor, I have more complete communications from earlier in July, the 13th and the 14th.
I'm looking for June, between June
Oh, I'm
18th
sorry,
and
yes.
June 27th.
Okay, that's July as well. Just looking for between June 18th and June 27th.
Fuck, I'm muted again. I'm trying to keep quiet because Dexter keeps going crazy over here. But I feel bad for the other people in court. Because this is the same reason why I hate streaming court live, is that these people take so long that the cases that were supposed to start at 8:30 don't start until 1. Like Eric Martin was supposed to have an 8:30 whatever pretrial hearing or whatever, and he didn't go until like 2 o'clock because people like this. But I'm going to skip ahead because I know I keep doing it. I'm trying to keep it quiet so he doesn't go nuts. All right, ready? Oh no. There you go, folks. So this is the 4-hour. Yeah, we're watching the whole thing, but because I know it skipped and I recorded it, I'm going to skip through it.
Green Cheese Apartments versus Gilda Mills, 2400141. And your appearance, please.
Good morning, Your Honor. Sidney Katz on behalf of plaintiff.
Okay. Just 1 moment.
Again, I'm going to try to skip through here.
Is still an active.
Okay, Ms. Wilbur, have you reached a resolution on your matter?
I have, Your Honor.
Okay. Do you have any questions?
No, I do not.
Moved for $1,038 through DHS.
And also, there's something funny. You might see them at some point. There's another case in here that people are kind of putting out, and you'll see her. When you see her, you'll know.
And some appearance for a plaintiff.
Gordon.
Mr.
laying a foundation and questioning a witness.
Which witness?
Both Ms. Branson, or I'm sorry, Mr. Branson and Ms. Collins.
Tad bit. There we go.
A little bit. All right, we are back on the record in the matter of Branson versus Collins. And so, counsel, did we obtain the other text messages between June 19th or June 18th and June 27th?
I obtained a more comprehensive view. It's still not clear what the entire conversation is.
Well, here's my question. Why am I receiving as exhibits partial conversations?
That's a good question.
Ms. Collins?
Just to show that that I sent that there was a bug problem.
No, hold on. But counsel, you submitted these, right?
Yes,
Did you look at them before you submitted them?
I did, yes.
And did you notice that there is a huge gap between June 18th and June 27th?
Yes, and I was anticipating, laying a foundation and questioning a witness.
Which witness?
Both Ms. Branson, or I'm sorry, Mr. Branson and Ms. Collins.
Okay. Did you show Attorney Amy? I'm very elementary when I say that. I'm very sorry. Have you shown Attorney Amy though that
Not
has
yet,
a list?
no.
Please show that to Attorney Amy.
Okay, yeah, I will.
I'd like to take a look at those. I'm not necessarily going to look to read them for any substance, because obviously Attorney Amy has not had a chance to review these. However, I'm trying to, doesn't even have dates on here. January 23rd, oh, that's what he goes screenshot it or something? I don't know what this even means.
In your honor, if I may, just for the record, if you look to the far right-hand column of the thing, that's the first time the date appears, and it appears to be at June 9th.
June 9th, June 10th. There's also Monday, June 10th. Okay, that's not even the relevant time frame.
Your Honor, I can point out the text message where it starts on Tuesday, June 18th, which is separately submitted. Yeah, it's the same text message.
That's not, okay. If text message conversations are going to be proposed for an exhibit, and this court is being requested to rely on the text message conversations to prove something that you're alleging, I need a full and complete conversation, not piecemeal. I'm not accepting those if they're piecemeal. Mr. Branson.
Yes, ma'am.
Your testimony is that you have these on your phone.
Yes.
Okay.
Yes.
Your phone is out in your vehicle?
Yes, ma'am.
All right. Please go out to your vehicle to grab your phone.
Yes, ma'am.
Thank you. All right, while we're doing that, I'm going to handle these matters right here. Mr. Beckstein?
Yes, Your Honor.
All right.
Yeah, and this is what I'm talking about. It's 5 minutes on, 10 minutes on, 10 minutes off, 20 minutes on, 30 minutes off.
That's correct.
Okay.
So we're gonna let this-
Remittance
Wait.
Credit Management versus Thomas Wilson, 24005. That plaintiff's motion is granted and the court will, in general, enter MB 300.
It's total.
Come on.
Counsel, we're back on the record in the matter of Branson versus Collins.
There we go.
Okay, so, counsel, we're back on the record in the matter of Branson versus Collins. Were you able to view Mr. Branson's phone for the dates between June 18th and June 27th?
Yes,
Okay, and are there text messages between the parties on those dates regarding the funds?
there are several text messages.
Are there any regarding bugs?
Yes,
Okay, now, I'm going to have you all go out there with Ms. Collins's phone, have her turn on her phone, get to that date, and you saw Mr. Branson's phone, correct, Ms. Amy?
I did, Your Honor.
Ms. Amy, now I feel like I really am.
I should prefer that. I like Attorney Amy with Amy.
And so please take Mr. Branson's phone out with you, counsel, and then you can compare the two phones to see if there's any messages that are not there, okay?
All right, thank you very much.
All right, Mr. Wilson, you're all set. Thank you. Have a good day.
Oh, thank you, Your Honor.
You're welcome. Okay, I'm just moving the material along right here.
And this is why this took 3 hours and 55 minutes.
Able to get back into it.
Let's see, what are we working with? Nothing.
Thank you. Very good. objection to the court reviewing the text messages, since now we know that there are not any missing text messages between those dates?
Your Honor, I have no objection about reviewing the text messages. However, I would say that it is not, we reviewed what you've asked us to review, which is between July 18th, June 18th, and June 27th. However, there are other text messages past that date that are relevant to this conversation about the bugs, including text messages where the bugs have been completely eradicated.
Okay, and I'm not saying that we won't, I just wanted to get those dates, the messages between those dates secured. Are the messages regarding that Council Amy is referencing, are those included in the documents that were submitted?
No, I'm not aware of that.
You're not aware of what?
The eradication of the bug issue.
Okay, whose phone are those on?
They're on my client's phone, but they should be on her client's phone as well.
Okay, good. I'm gonna have the four of you go out into the lobby and compare those. Check. Thank you. All right, we are back on the record in the matter of the City of Wyandotte versus Brian Gray, 25225. And counsel, your appearance.
Again, this is talking about it. Just
Since the matter being via Zoom, hence the arraignment, we wait for more reading.
all right, weirdo. Stop talking. Actually, this case
Mr. Gray, your name for the record, please.
is good, but we're gonna move past it.
All right, thank you. Sir is going to order
That text message.
Okay. I want to see him walk back in.
Mr. Shumke, I think that's everybody.
I believe so. There might be something later today, but
Miss Emke.
Thank you. All right, so, Sherry, can you please?
Oh, and before we get into this, because you guys are talking about booze and body cam, I'm currently drinking out of this here fancy Mandalorian mug, or I don't even know what this thing's called. I'm drinking Arizona hard tea or whatever the hell that they sell now. They sell the tea and the juices. I got the tea because I'm classy. But that's what I'm drinking tonight. Whatever you guys are drinking, leave it in the chat.
Can you give me the last thing? Okay, so we are back on the record in the matter of Branson versus Collins. And so, counsel, you both had an opportunity to review the subsequent text messages after June 27th, correct?
Correct. That is not correct, Your Honor. The defendant walked away and did not allow me to actually look at her phone. She literally walked away from the conversation. And
Don't interrupt, please.
And I asked her counsel whether or not there were text messages subsequent to the one that we have on August 18th. We have not been able to, but we have, because we have.
August 18th?
Yeah, so we have a text message specifically on August 18th. Hey, the guy came out, he sprayed, this should take care of it. She says, thank you. That's the last text message my client has related to any book issues.
All right, okay. Do you have any of those text messages, ma'am?
Yes, ma'am.
Is she allowed to be using her phone at this moment?
As long as she's just looking through her text messages, so.
And remember what we were talking about with, let me turn it back to this here thing. Remember what we were talking about, or what I was talking about when I said the landlord nailed it. He did exactly what he was supposed to do about the bugs, said exactly what he was supposed to do about the bugs, and she didn't want that on the record.
Mr. Klala, did you see on your client's phone the part about the bugs being eradicated and your client saying thank you?
I saw that conversation. I don't consider it proof of any eradication of the
That
bug
wasn't my
issue.
question.
Okay, I saw what you're referring to.
Okay. Did your client allow Attorney Amy to view the text messages that you were viewing?
No, but that was an accident, Your Honor. She walked away. I thought we were just confirming that they both had that text message.
We were, but
Okay.
you were, the two of you were. How is Attorney Amy supposed to do that if your client walked away with her phone?
Okay, yeah, you're absolutely right. I'm sorry.
No shit, she's right.
So the message that somebody came out to spray for the bugs and your client saying thank you, that doesn't mean that those were eradicated.
No, they weren't. There's still a bug issue.
Okay, when did your client then re-notice Mr. Branson regarding the bug issue?
I have to ask her the specific date if she can recall it.
Okay, here's some concern that I have here. Your client is alleging this matter should be dismissed because the home is not habitable, okay? Or it's not fit for living properly. Did you find the text message? Don't stop looking until you find the text message, please.
Quick, hide the facts.
And you've submitted a plethora of text messages that are incomplete. So I should not have to be the one to essentially babysit step by step how the evidence should be brought forth and communicated between counsel. I should not have to do that. But yet I am having to do that. Because your client is giving you partial information.
So let me bring myself up again. So, so wait, the texts both do and don't prove the bugs exist. Yeah, it proves that she said something about the bugs, and that's where she wanted to stop and be like, yeah, I told him about the bugs, and he didn't do anything. When in fact, he said, oh shit, thanks for letting me know. I'll have the exterminator come out. And the exterminator came out, sprayed where he needed to spray, identified exactly what breed, genus of bug it is, what they like, what they don't like, where they like to hide, where they don't like to hide. And she didn't want that in the record or on the record.
I don't know if you've attempted to get the information from your client and it's not able to be given to you at the time you're asking. I don't know. But to ask this court to dismiss this matter.
It doesn't say they were eradicated.
What does it say? Is it right there?
Yes.
Okay. Show Ms. Amy what that is. Attorney Amy, the phone.
They said they're harmless.
That's August 18th?
Yeah, and that's not the, if you'd like, Your Honor, I'll read the entirety of the text message into the record and they can confirm whether it's accurate or not. If that's,
This is August 18th.
Yes.
Did they say they were
Ma'am,
eradicated?
I'm not asking for your testimony. I'm asking if you have pulled up the text message
Yes.
that is being referenced regarding
Yes.
somebody coming to spray for the bugs and you saying thank you.
I didn't say thank you, but yes.
Your Honor, the very
Yeah, I did say thank you. You're right. I did say thank you.
Okay,
Turns out she did.
I'm going to have you follow along on your client's phone. Attorney Amy, please read into the record
Thank
the
you, Your
date and time and who it's from, please.
Thank you, Your Honor. From Mr. Branson to Ms. Collins on Sunday, August 18th at 2:40 p.m. He identified the bug as a springtail, basically like a gnat. They don't bite, sting, do anything. Totally harmless. They like damp areas. He recommends every time you shower, use the vent. The underside of the tub is totally dry when we ran a camera under it. Spray for them. Google springtails. This should take care of them. Hung the mirror and your doorbell also. I ordered some LED lights. It says LED, but I take that to mean LED lights for the basement as well. And untimed response by Ms. Collins. Thank you so much. When you have a moment, can you please show me how to take the doorbell off and I can hook it to the Wi-Fi and app. Sorry I tried and I felt like I was going to break it. Also, the mirror looks great. Thank you so much. I appreciate it. And then there's one response by my client on the sheet that I have that says there's a small orange tool in the box. Use that to unscrew the step screw on the bottom of the doorbell, then slide it up.
Okay. Did you then send, so that sounds to me as though Mr. Branson fulfilled his obligation at that time as it relates to the bugs. Because he had somebody come out to the home, sprayed for the bugs, determined what type of bug they were, determined that there weren't any leaks because underneath the tub was dry, indicated what type of bug it was, and that it's a bug that, it's a harmless bug in the sense that there's not any, I presume like a bee or something like that, where it would be stinging or something, and that what type of areas that particular bug likes. Now, did the bugs return?
Yes.
What date?
They've been returning off and
No,
on.
ma'am, it's your burden.
I don't know the exact date.
Ma'am, it's your burden. You have filed a motion to dismiss and you're alleging that there's bugs and that that's a reason why Mr. Branson should not have checked box number 7. So what other dates have the bugs returned that you communicated that to Mr. Branson?
I can't give you an exact date, so I'm not gonna lie and make one up.
Okay.
If that's what
The judge doesn't even want necessarily an exact date, but like what month did they return? Did they return in the beginning of the month, the end of the month, fall time, winter time? Like give the judge something. Don't just say, oh, you just want me to lie. It's like, no, she just wants some sort of information of if they came back, when did they come back and when did you tell him that the bugs were back?
you want me to.
No, it's not. I don't want you to lie and make one up. Okay, so we'll move on from the bug problem. The kitchen not finished. What's wrong with the kitchen?
When I moved in, I was told that I was gonna be getting a whole brand new kitchen. I was shown their kitchen. When I was walked through to look at it, when I moved in, they said, this is the kitchen you're gonna get. I was given, you're gonna have cabinet doors, brand new flooring, everything. And I said, oh, great. They just said, because it was originally one price on Zillow, they said it's gonna be $1,500 when you move in because.
Yes, exactly. So personally, you guys can leave it in the chat. I'm pretty sure you guys would all agree with me on this, but if I had bugs in my house and an exterminator came and sprayed for it, my landlord was like, yeah, you're good to go. If they came back, I would immediately upon seeing those bugs the first time be like, bro, those springtails that you sprayed for, they're back. Can you come spray again? I wouldn't keep that shit to myself. Like, that's the dumbest thing. And then come to court and be like, well, yeah, they got again, but I didn't let anyone know. It was a secret between me, myself, and I.
Because we're doing this kitchen.
Hold on. What was the amount on Zillow that you originally were going to rent the property for?
$1,300.
$1,300 a month?
Yes.
Mr. Branson, is that what the original rental price was $1,300 per month?
It was also on Zillow
Ma'am,
Street.
hold on. I'm talking to Mr. Branson right now.
Honestly, I don't believe so. I don't have the Zillow thing. My wife puts the Zillow on.
Okay.
No, the Great Pond, the lease was $1,500. I don't believe it was for $1,300. I'm not gonna say in
Okay.
confidence because I don't know what the Zillow.
Did you at any point increase the rental price based upon a new kitchen?
Absolutely.
Okay. Did you take Miss Collins into your home to show her what kitchen she would be receiving?
She's been in her home, but not for that reason.
Okay.
No.
Is there a working kitchen in the property,
Oh, absolutely, yes.
Miss Collins?
Yes. But to be fair, the outlets don't work. For the first 3 months, if I used just one appliance, the entire kitchen wouldn't work.
Okay. Did you notify Mr. Branson of that?
Yes, I did. And then December 1st, when I found out one of the outlets was start fire, I let him know.
When did you find out an outlet would start fire?
On December 1st, I went into the hospital and I said, could you fix the outlets? I'm in the hospital, I'm out. He said, okay, I'll go in there in the hospital. When I went to try it in November, when I got in the hospital, I was finally up and I was able to try it on my own. The first time I did on December 1st, I let him know. He rushed over on December 1st, I have it on videotape. He said, well, if it catches on fire, I need to know. And he came in my house and he was, well, I need to continue.
Hold on. If he says if it catches on fire, let me know, it doesn't mean that it's an outlet that's going to catch on fire.
No, it's right, it smokes if I plug something in. So he comes over, because I said.
Smokes?
Yes, I have an
Which
outlet,
outlet are we talking
the
about?
one in my kitchen,
I understand that, ma'am. Which specific outlet?
the one by the back door.
Okay, so Mr. Branson, the outlet by the back door,
Yes, ma'am.
does it work?
Yes, it works. I mean, she's plugged appliances. There's no evidence of a fire. We have replaced that GFI.
When did you replace the
The
GFI?
first time she complained about it, we replaced and put a brand new GFI.
Okay, what date was that? Okay, what month?
It would have been right after she made the complaint.
I don't know when that was.
I'm sorry. I don't know when her first complaint about the GFI was.
Okay, would it have been summer
No.
or winter?
I believe it was in the fall, actually.
Okay, so went into the hospital?
She's
Or
been
while she was in the hospital?
No, she was in the hospital when I.
So the GFI was replaced. Would you agree with that, Ms. Collins?
While I was in the hospital, correct?
Okay. And then your testimony is that even after it was replaced, it still didn't work.
Correct.
Okay. Well, the inspection next week will take care of that. And,
Your Honor, there's a.
and you said that there were 3 other outlets that did not work. Where were those? Where are those?
There's one in the dining room that does not work at all.
Okay, you said the kitchen. There are 3 in the kitchen. Is it an eat-in kitchen or is there a separate room for dining room?
There's a separate room in the dining room.
Okay, so we're talking about specifically the kitchen.
Oh, there's another one in the kitchen that, well, the kitchen, if you were to plug one into the other, then the whole kitchen goes out.
Yeah, I don't know what one into the other means. I need you to be specific for the record, okay? And I also am asking you, you said there were 3 outlets that do not work. Where are those 3 outlets located?
There's, well, the 2 right there that I was talking
Yeah,
about,
okay.
that start,
Hold on. You keep saying right there. I don't know where right there
the
is.
one by the back door.
Okay, there's 2 by the back door?
No, I'm talking, to me, 2 outlets are the 2 plugs right there that are together.
Okay, so it's 1 outlet, 2 plugs,
Correct,
not 2 outlets. Okay, so it's 1 outlet with 2 plugs.
correct.
Is there another location in the kitchen that the outlet with 2 plugs does not work?
No, that one, that's.
That's the only
yes,
one?
That I
Okay.
know of.
Okay, so what part about the kitchen does not allow for the home to be fit for its intended purpose?
What I was talking about with the kitchen, ma'am, is they baited and switched me with the kitchen, and I have proof of that.
Okay, what's your proof of that?
My proof of that is text over and over, and then in the hospital, they finally said,
Okay, where are those text messages?
can I show you on my phone?
Well, are those included in any of these exhibits? Because we have 105 pages of exhibits, which I'm presuming, since the kitchen is an issue, that they're going to be in here somewhere.
I know, I gave it to her to submit.
While she's looking, if I may, Your Honor. just
Yeah.
brief
The
argument.
fridge and stove are coming
Oh, hold on,
in.
ma'am. I'm asking you to look for them, not read them right now.
Thank you, Your Honor.
even if what Ms. Collins is saying is true, which we disagree with, it doesn't make the kitchen uninhabitable. It doesn't make the house unlivable to the point where she can evade any form of rent for that. Moreover, every conversation that they had about possibly remodeling the kitchen was put off because Ms. Collins indicated she had cancer. And they didn't want to go in and do a major construction project while Ms. Collins has cancer. And if you look at the entirety of the text messages, which she did not submit, again, that's what you'll see. You'll see that there was a conversation about possibly remodeling the kitchen and it being put off because Ms. Collins had indicated to the Bransons that she had cancer.
Okay, so, yeah, when was there a conversation about remodeling the kitchen?
The remodeling the kitchen was, they're supposed to be done before I even moved in because I signed the lease May, I believe, 24th. I didn't move in until June 17th. It was supposed to be done before
Hold
that.
on, but I think I saw somewhere that you were dropping things off June 2nd. So you had access to the property.
Upstairs.
You had access to the property June 2nd. So whether or not you moved in fully after that, I don't know, but you had access to the property before
Just
that.
totes.
I recall from the last time, from 2 times ago, that you made the argument that you were not in there for the full month of June, so you should have an abatement for certain dates of that. You had access to the property, and you moved some items in June 2nd. Whether you moved the rest of them in or not after that, absent some reason that stems from the home not being ready to move in, I don't see that that's a basis to abate any portion or prorate any portion of June. However, the kitchen being remodeled or not being remodeled, when you're told it would be remodeled, if that's what the conversation was, and it wasn't remodeled, I don't find that that would be a basis to find the home not fit for habitability. And was there a discussion to raise the rent after the kitchen was renovated?
No, absolutely. I've never raised the rent. I had no intentions of raising rent.
Okay. Ms. Iqbal, what you got there?
Exhibit 6 contains text messages about the kitchen.
Okay.
Your Honor's probably not gonna love it because it's the similar format as before.
Well, you're correct. July 24th.
Also, I'm at a little bit of a loss. I thought we were arguing a motion for summary disposition based on the certificate of occupancy. So I was intending to call witnesses for a, evidentiary hearing and cross-examine them and lay a foundation for these exhibits for those underlying issues.
Your Honor, I warned opposing counsel that she was mistaken. I gave her fair warning via email in writing. I think this court is actually purview to those conversations. I think they have happened in line with the conversations related to the proposed order that Your Honor had the ability to view this morning. And instead of, double checking and crossing her T's and dotting her I's, Ms. Duckall came in here unprepared for this hearing after submitting documents that are inappropriate and abjectly in violation of the Michigan court rules and rules of evidence. Your Honor.
Okay, so I'm going to stop right there for a second. So, like I said at the beginning, this new female attorney for the landlord, I'll put my hand up. He thought I was going to drop something. This new attorney is Periwinkle Mason's kryptonite, where she just said, "Oh, you thought that? It's crazy because I informed you differently via email." I think the court should look at those because you knew exactly what you're doing, and now you're trying to weasel your way out of it. And she's literally just keeps doing it the whole time. And I love it because the other guy was kind of like timid and just kind of wanted to play games. And this one's like, no, I'm going to go for your throat.
I'm a little tired from opposing counsel trying to throw the evidence under the bus and say this, that, or the other thing, when all I'm saying is there's procedure to be followed for a motion for summary disposition based on immunity granted by law compared to a full evidentiary hearing while calling the witness.
What immunity are we speaking of? Because because the court ruled on, in fact, let me pull it up. The court ruled when the parties were first here on the 14th. That Ms. Collins was going to be relocating. She, number one, said she wanted to relocate, and the court ruled that the plaintiff is entitled to recover possession of the property. What I ordered the parties to brief was the issue of where the money that's held in escrow is to be released, based upon 2 things. Number one, your client indicating that she didn't have access to the property for the month of June or couldn't move in until June 17th, so she wanted a prorated amount. Also, because your client alleged that that the certificate of occupancy plays a role in where that rent money that's been deposited in escrow goes. You subsequently filed an appearance, actually, let me just see something here. That was on the January 14th date. We set this for an in-person trial for February 7th. And that's when the court entered the escrow order as well. Then on February 11th, because I must have gotten removed February 11th. February 11th, the hearing was held. We adjourned for the next hearing to address the issues. June 2024 rent, defendant claiming she overpaid utilities, plaintiff going in all hours of the night, stealing mail harassment. Also, parties to brief the issue of no certificate of occupancy and collection of rent. Then we moved into the 18th, and I had originally stated the wrong time. And then the parties were here on the 18th, except for Ms. Collins. She was present earlier, even though we noticed everybody that the time has changed. And we adjourned the matter today regarding escrow money and utilities and 2 other issues that the court stated. You also, counsel, at that time, wanted to address your motion, amended motion to dismiss. So that's what we're still on. We're still on the amended motion to dismiss. I started with that because if I'm granting that, then the rest of the matters appear to be moot as far as that goes. However, so that's where we're at right now. So that is what we're here for. So as it relates to the kitchen, what does that state? What is that? And I will also make a statement regarding the evidence. And counsel, you've submitted evidence that is incomplete. You've submitted these exhibits that are incomplete.
I suppose I was just looking for clarification from the court why, to me, this is a motion for summary disposition under 2.116C7 and C8. It's not an evidentiary hearing, so I have testimony and to not be able to, take testimony of someone that I'm calling with evidence that I can build a foundation for. It's just procedurally, I can't understand. I do understand that you're allowing, and thank you, allowing to hear argumentation on habitability for the number 7 that was checked. I do understand that and appreciate that.
A motion for summary disposition wasn't filed, so this is not a summary disposition matter. A motion to dismiss was filed by your client. An amended motion to dismiss was filed by your client. You're relying on that motion that was filed and then submitted additional exhibits. So we're back to the kitchen.
Could you do me a favor and give me the court rule for the motion to dismiss?
The court rule?
Yes.
Your client filed the court. I don't know what she filed it under.
I don't think she filed it under any court rule.
Well, then I guess, you're claiming that it's, let's see here, property item 7. That is what she referenced. Or, I'm sorry, item 7, non-payment of rent for residential property, item 7.
I'm just asking for the court rules so I can have some guidance in terms of the motion to dismiss compared to my interpretation of it substantively was more of a motion for summary disposition. So if I had the court rule for the dismissal that we're operating under, maybe I could have more clarity there.
Well, presumably I'm operating under 2.119, which is a motion, and your client filed a motion to dismiss. 2.116 is a motion for summary disposition, and there has.
All right, hold on, guys. We gotta slow this down because I'm starting to not be able to understand the landlord's attorney. She's talking mighty quick.
There has to be a 20-day notice, and there has to be a time for response to be filed, affidavits, and all that. This was not filed as a motion for summary disposition. This was not filed that way. So we're proceeding as a motion to dismiss.
I don't believe she filed it in the first place. I filed a brief.
Who filed the motion to dismiss, this handwritten motion? Who filed this motion?
That is an exhibit. It wasn't filed. You had ordered briefs, and she had written that before.
No. This was filed.
Oh, fine.
This was filed.
Okay.
Prior to your appearance, counsel, this was filed because this is what we did not proceed on February 7th because there hadn't been sufficient notice to plaintiff.
Okay.
So that is why we are handling it in its entirety now, because now everybody's here, everybody's present. That is what we're doing. So, but if you want to stipulate that the property was habitable and we don't need to have further inquiry regarding item 7, then we can proceed with the next issues. That's fine. Or we can continue to proceed with whether or not the property was kept fit for its intended purpose. pursuant to number 7, the complaint for recovery of possession of the property.
Okay, I would like to request a continuance, please. For the reason that I was under the impression we were arguing in terms of the disposition of this case under the law in regard to MCR 4.201 and MCL 125.530. I'd like to re-subpoena the witness that I had subpoenaed for Tuesday's hearing in order to have her present.
Which individual is that?
It is.
Okay, let me get into this real quick. So first off, I was about to say you get to look at Dexter's butt. The witness is literally the worst witness for what the tenant's lawyer wants her to be a witness for. Yet she's going to keep hounding this, and then shocker, the good attorney for the landlord is going to basically give her a public execution on YouTube.
Kelly Roberts, she works for a building.
Okay, you subpoenaed her to be here this past Tuesday?
Yeah.
Was she here?
No, she wasn't.
No, she was not. Okay, so what does Ms. Roberts' presence or testimony, what's the relevance regarding the motion to dismiss?
I want to ask her about any former inspections of the property.
That would be as it relates to the money held in escrow as to where that goes, but I don't know that I need her testimony for that, but that I'll defer that for just a moment. What does that have to do with the motion to dismiss?
What it has to do with the motion to dismiss is, again, going back to how this is a little convoluted in my brain, because you have MCR 4.201, which dictates that residential properties have to be kept fit for their intended use and purpose.
And remember, this is the same, what was it? I believe it was MCR. It's the same thing she tried to get this dismissed over at the beginning of the trial or beginning of the hearing. And Judge DeSanto's was like, yeah, no, that's not going to be a thing today. And this is like the third time she's tried. And again, this is 2 hours and 12 minutes of a 3 hour and 55-minute video. And she's going to keep trying it, even though she just keeps shutting it down.
Purpose and habitable as it relates to number 7. Then you have MCL 125.30. So to me, if there's no certificate of compliance, and then on top of it, factually, it's not being kept fit for use, especially with the amount of evidence and the amount of issues. If I have testimony from a city employee stating that there's a history of problems at the residence, or some further information that could push the burden of proof so I can actually get my client the justice that I'm attempting to get now, that's why I'm asking.
If I may briefly respond to those her oral arguments.
Finish
Support. First and foremost, my client has been delaying this. Like, this has been pushed out a number of times, like a multitude of times, and we're here today. Client's mistake of what was going on because she misunderstood the nature of summary proceedings as opposed to a summary disposition motion. I don't think it's good grounds to continue to delay this. This court has already ruled that this tenant must leave the property, and now it's about where the money goes. The defendant has the burden of proving whether or not there should be some money released to her or all of the money should be released to her. That's her burden. And she came without evidence. Even the evidence that's in here is not relevant. Moreover, the witness that she was trying to call from the building department as it relates to habitability is not necessary, nor is it relevant, because the past history has nothing to do with what's going on today. And the actual condition of the property as it sits today, Your Honor. So that witness is irrelevant. And the reason that witness didn't show up last time is because sister counsel subpoenaed her incorrectly. A subpoena was submitted to the city via email 3 days before the hearing, when the court rule clearly requires 7-day notice with personal service of a subpoena for a witness to appear. So sister counsel didn't even do that correctly to get her witness here. And she could have, she could have subpoenaed her for today, but she made no effort to do so. And if her claim is that this witness goes to where the money goes, that issue is before the court properly, because even if we're not having the full proceeding today, that issue, the specific issue of where the money goes after this hearing is over and you make a determination of habitability, would have happened today, pursuant to the defendant's own motion. And it is further clear that the express language of the statute that we're talking about, which is actually, hang on. which is actually MCL 125.528 or 125.530 subsection 5 dictates where that money goes. And the money is supposed to be held by the city. And the money is supposed to be released to the plaintiff for the purposes of completing repairs due to the express language of that statute. And after whatever's left over, after he has been reimbursed for the repairs, is intended to be released to the landlord. It is clear. The statute is clear and unambiguous in its terms that is what happens with the money that is held in escrow, Your Honor. So that witness would have been more appropriately here for the motion to dismiss. And as it relates to the issues that were brought forth by the defendant in her motion, and she's not here today. And that witness is not relevant to move forward to proceed on the issues of habitability, Your Honor, because that witness has not inspected this property.
I sent an email to the witness as a courtesy. I sent it out, priority mailing, but I was retained 4 days before this was. I'm just a little tired of hearing, I didn't do my job, I didn't do my job, I didn't do my job. When I'm not talking about that. Yes, there's a burden of proof. Yes, there's evidence. I'm talking about being able to fairly get testimony from the witnesses I intend to call and to be able to lay a foundation for my evidence. Because a lot of this is trending into what my client's defenses are. It's not relevant to the motion to dismiss, it's what her defenses are.
Okay, what are your client's defenses?
Well, my client's defenses obviously primarily is that it wasn't fit for use.
So your client is stating that when this complaint for non-payment was filed on January 3rd, that the property was not in a habitable condition.
Correct.
Okay. So you subpoenaed Ms. Roberts. You're intending to call Ms. Roberts as a witness to address the habitability of the property.
Correct.
Okay. When did she go in to look at the property?
I don't think that she has.
How would her testimony be relevant?
Because she's the custodian of records for the buildings department.
Okay. But if she has not looked at the property, how can she determine what issues would affect habitability?
I would be more than happy to talk about what issues affect.
All right, so before we get too far into this, welcome Colin Raiders. As you know, or maybe you don't know the rules, any super chats, memberships, nonsense, the dog gets a treat. $20 super chat or $20 worth of members, the dog gets a genuine cow kneecap. And he'll be in and out of his little camera angle all night. So this is going to be the Judge DeSanto dealing with Periwinkle Mason and the tenant from hell. Enjoy.
After the inspection is done, that's scheduled on Wednesday. But I'm absolutely insisting that someone from the city provide testimony related to this property.
Okay. Has the property been condemned?
No, Your Honor, it has not.
Okay. So have there been citations issued to Mr. Branson regarding property maintenance violations?
No, Your Honor, it has not.
Has there been any documentation that would suggest that the property in and of itself is not habitable?
No, Your Honor, there hasn't.
Ms. Aquila?
So I have significant evidence from my client. There are several pictures that have been submitted to the court.
Okay, let me clarify. Any of those photos, do those render the premises inhabitable?
Yes, the mold issue.
The mold issue, okay. When did the mold issue begin?
Before I moved in.
Okay, did you look at the property before you moved in?
Yes, and I asked him.
Legal fiction for $19.99. So this bag contains a whopping, let's make you big, bud. Yeah, he needs more lighting. This wasn't the spot that it was meant to be in, but that's the spot he kept laying down in, so we had to adjust today. Dear Lord, these things are legitimately in, what's it called? In plastic. So give me just a second. I have to get my knife. It's either I get my knife or I shoot it open with my gun. I'm pretty sure Mrs. Kafar would have an issue if I shot open a cow kneecap. All right. That's it. Good boy. Here you go. There's a genuine cow kneecap in all of its glory. All right. Let's bring it back to, there we go. Thank you.
He told me it wasn't mold. And
Okay, did you have a mold test done?
No, I believed it.
Then how do you know that it's mold?
No, I've now since.
Okay, where's the mold test?
I'm getting it back right now, and I'm also.
When did you
getting
have
it
the
home.
mold test completed?
About 3 weeks ago.
Okay,
That's the.
which photo is alleging the mold? Let me get to that. Which photo is alleging the mold?
Judge, I think I can help with it.
What's that?
Photographs provided by the defendant in this case are all black and white. It would be absolutely impossible for you to look at those photographs to make any form of determination.
Oh, is this where Miss Ashley comes in, where she's got color
That's right.
photos that she's gonna screen share?
Not only color photos, but we have the body cam. And we've been able to, the body cam for the police is extremely
Does the body cam show any of the alleged mold spots?
I believe it
No, I'm not
does.
asking for belief. I want to know, does it?
It does.
It doesn't show any mold spots because no mold spots exist, but it does show the general condition of the area in which this defendant claims there is mold.
Okay, Ms. Miller, I really need for you to please stop talking Collins, while somebody else is talking, because it's affecting the record. Okay, and I'm having a hard time focusing on what's being said, because I'm hearing you talking, I don't know if I'm just hearing noise that way. So, where are the photos? So the photos had to come from somewhere, were they on a phone?
No, and I do have color copies.
See the color copies, please.
I have black and white here.
Well, then why don't we have the color copies here?
Because I need a continuance, I need more time to adjust my exhibits and to be able to run this effectively.
Well, if there's an allegation of mold, I'm not sure why the color copies weren't brought. Was it on somebody's phone?
No, what?
Your phone?
Yes.
Okay. I received actual printout pictures, that's why I said no, I wasn't aware of it.
Okay.
When I'm looking at the screen, is Kennedy still available or?
She's not on here, but I mean, if she wants to zoom back in, I can embed her back in.
We're killing her.
But wait on that, because I'm not sure if I'm going to view the body cam or not, I don't know.
We're killing your vacation trip, I'm sorry. I feel bad for her.
Okay, yeah, I'm just looking for you to pull up the pictures.
They're all in different spots, so I have more, they're in three
Pull
different
up
spots.
one, pull up one for now.
I'm trying to find the best one. Here's a good one.
Okay, show it to council. Terry, can you facilitate, please?
There's a black one.
I'm not asking for additional comments, I just want the photo, please. Okay, so this is, looks like, and where is this photo taken? What room?
In the basement.
The basement. Okay. Is it, well, this looks like there's brick and then maybe cinder block? Okay, okay, this is on the block itself. Is there anything on the walls? Is there any drywall in the basement?
No, Your Honor.
Yeah,
Yes,
there's drywall as well, yes.
there's drywall. Is there drywall in the basement, Mr. Branson?
No, it's an unfinished basement.
Okay, ma'am, do you know when I say drywall, I'm not speaking of whether or not there's a wall that's dry. Drywall is it's a material that people put over 2x4s or whatnot to create actual walls in rooms. Is there any drywall in the basement? No? Is that no?
No.
Okay. All right, well, is there another?
Your Honor, I have a photo that was submitted in the exhibit, so it is black and white. But you can see a significant spot that could either indicate the leaking itself or the mold, which may go hand in hand.
Your Honor, even if it shows either or, like counsel's own statement is an admission and you can't tell what it is.
No.
And let me say this.
I'm gonna look grab another picture, please, that shows more of the wall itself there, please, and not just a close-up of the spot, please.
And let me say this, Your Honor. My client purchased in the summer, last summer, a dehumidifier for the basement. It's been running full time. And if there's mold in the basement, let's ask Ms. Collins why she has the basement floor filled her personal belongings, because everybody knows that if there's mold in an area, the spores will get on your belongings. But she is storing her personal items in a place that she's claiming is filled with black mold. It's inconceivable. It's irreconcilable.
Not only that, and hopefully you guys can hear him crunching on that damn kneecap. And that's why he's between me and the door. You can see the door has windows, and my boy cat keeps getting in the window and trying to look at him. But no, so she's keeping her stuff on the floor in the moldy basement. And if you remember from the beginning of this, she was claiming it also flooded in the basement regularly, and that the window in the basement wasn't connected to the basement wall, and there was rain getting in, wind, cold, yet she's keeping all of her shit in the basement. So it just doesn't logically make sense.
With her current statements.
Okay, why does your client have a dehumidifier in the basement?
Because Ms. Collins had said that it smelled musty. So because it smelled musty, he bought a dehumidifier in the basement, just to appease her, to make the damp smell go out of the basement.
Okay.
Moreover, it's very clear that Ms. Collins did not order a mold test until we were well into these proceedings.
Okay, so Ms. Collins, what did you take a screenshot of?
I'm just showing it closer.
No, I didn't ask for it to be closer.
That's fine.
Show the picture that you just pulled up and you took a screenshot of. I don't want the screenshot, I want the
I'm going to
picture.
read the screenshot. There you go, right here.
Please show, Terry, please show council.
Come on. I'm gonna get it so it's not cropped or anything. Hold on.
Can we show the store client?
Yes, what is this a picture of? Where is this picture?
He has, before I moved in, he had, shelves blocking, window. The window I'm saying that's like almost falling off. He has a shelf holding that window
Okay,
in.
this is behind the shelving?
Yeah, that's behind the shelving.
So what part of this are you referencing is the mold? The part of the
Right
bottom?
down, yeah, right, all down by
By the
there.
shelf?
Yeah, he's trying to hide it.
Well,
He has stuff on there, behind there.
Ma'am, hold on.
Okay, while we're holding on, Ed, if you noticed, he's still there. He's just chilling in the seat. But from the last case, when the tenant's attorney was like, oh, I have anxiety, I don't like confrontation, and accused that attorney of being like overly aggressive because he turned his back on her assistant while him and the attorney were talking. He's still there, but it seems like they got somebody specifically to fluster her attorney, and it's working.
That doesn't necessarily show that that's mold. It shows that it could be dark brick or discolored brick. I don't know that. Can you please show that to Mr. Branson?
He has stuff.
Ma'am, when did you become concerned about the mold that you're alleging?
After I got out of the hospital, and they told me that it could be something in my house.
What could be something in your house?
That gave me my disease.
What disease is that?
that I have this low vitamin thing that my body's not reproducing.
Okay. Okay, well, when did you get out of the hospital the last time when that was stated to you, ma'am?
In October, the
Okay.
last week of October.
Okay, and so you ordered the mold test 3 weeks ago?
When my doctor said he finally put to me, I first smelled something when I first moved in and he's
Right, that's why you have the dehumidifier.
Yeah, that's why I put it in there.
Okay, right. And
But
that's
I was
never,
I was never told until like 3 weeks when I moved in that the basement flooded. He sent me a text, oh, by the way, the basement floods.
okay, hold on. Does the basement flood, Mr. Branson?
No, ma'am, not at all.
Does the basement flood when there's heavy rains?
Absolutely not.
Has the basement ever flooded?
No, ma'am.
Did you ever tell Miss Collins that?
May I address?
Did you ever tell Miss Collins the
No,
basement
no,
floods?
I've never told her the basement floods, because it doesn't. I have an adjoining basement, and I have no flood, never have. I've lived there since 1977, and I've never had a flood in that basement.
Okay, ma'am, at what point did Mr. Branson tell you that the basement floods?
Within 3 weeks of moving in.
Did the basement flood within those 3 weeks?
The first time it got wet, yes. It was
What does that mean?
the walls got wet and the ground got wet.
Okay, did the ground get wet near where the walls got wet?
Yes,
And would that wall be near where the window is, needs repair?
yes.
Okay. So, okay, at any point during any of the heavy rains, did you have water covering the entirety of the floor of your basement?
Not.
Yes or no?
No.
No, okay. So it's quite possible that there's some leaking water from the window, went down the wall and on the floor there. That's possible. Okay,
Your Honor, Exhibit 7 is a screenshot of a text message from July, and it tends to indicate that Mr. Ranson did know of the flooding in the basement.
hold on a moment.
Sure.
Exhibit 7.
In fact, Your Honor, it actually says exactly what Mr. Branson said, that the basement has never flooded. But it says, hey, if it's wet down there, let me know, but it's never flooded. Literally, that's what it says, despite the ill-conceived reference that sister counsel would like you to make.
Possible.
There's nothing in
Hold
it.
on, I can't even find that yet. Hold on. I don't even, oh, there, I'm coming close. Okay. All right. Sorry for the, okay, Tuesday, July 9th at 10:59 PM. Sorry for the late text, but with the possible heavy rain, make sure you let me know if you're getting wet tonight or tomorrow. And then, Miss Collins responds, would that be in my room or the basement? Sorry if you just get, and then it cuts off. And then there's nothing else after that.
Yeah, because they,
And then and I will note that there's a handwritten note on here, which there also shouldn't be handwritten notes attached to exhibits that said new basement floods before I moved in with a question mark. So,
and Your Honor, the reason she cropped that is because the next text message chain, which me and both Ms. Davala were able to view when I was scrolling through my client's phone, clearly states, no, it's never flooded. Like, it literally says that. That's why she.
Did you both review that, counsel?
I was looking at the bug problem, so honestly, I, probably should have been paying attention more, but.
Okay, well, you're focused on that was the purpose of looking was for the bug.
If her saying she should be paying attention more doesn't sum up this entire 2 hours and 33 minutes that we've just watched, I don't know what does. It seems like she's behind the 8 ball on literally everything that gets brought up in this court case.
Bug problem. Okay, where's that message?
We're pulling up, Your Honor. Your Honor, can you give us the date of that again, please?
July 9th.
That's not right, okay, because he told me this one.
correct?
Yes.
So, yeah, from Mr. Branson, sorry for the late text, but with the possible heavy rain, make sure you let me know if you're getting wet tonight and tomorrow. Miss Collins, would that be in my room or the basement? Sorry if me just getting home woke either of you. Mr. Basement, we have never had a supposed to get nasty. You didn't wake me. I'm on a call for work, so up all night, and I just realized wording and apologize. Miss Collins, never apologize for things and want the best. Also don't want the worst in long term. I will watch out. I have to do laundry anyways, and was unpacking a little to get ready for Sky. Okay, and then they talk about Sky, which I don't think is relevant for the I don't even know who Sky is. But anyway, so it acknowledges that there's not any flooding, but since there's going to be a lot of rain, he wanted you to look for that. But it acknowledges I find that there's flooding in the basement. But I still haven't heard any testimony that would support your client's motion to dismiss on number 7. Now, whether or not the monies go to whomever, that's a different story. Okay, you're saying that you didn't have room with heat. You have a room without heat and air conditioning. Upstairs front room.
Again, I'm looking to call a witness, and
As it relates to the heat and air conditioning in the room?
yes, as it relates to everything,
No, I'm asking specifically about the heat and air conditioning.
also that, specifically that, yes.
Okay.
I've requested a continuance because I need to be able to, like I say, lay a foundation and call Ms. Collins. I'd like to call Mr. Branson. I'm trying to subpoena and call someone from the city.
Okay, so counsel.
So you say the rumors are true, says the mystery mold has affected her brain. It must have been contagious and infected her attorney as well. Because neither one of them are making a lick of sense right here. And bad company, I can't understand something. If this house is so full of mold and bugs, etc., why in the hell does she want to stay there? Why doesn't she just move out? Like I said at the beginning, half the time she's talking about in the other hearings, oh, I need the money so that I can move. And then the other half the time it's, oh, well, they don't have a certificate of like occupancy, so I don't need to pay them rent and can stay forever. Like she's trying to play both sides of the coin while being wrong on both of them.
So I've heard your request for a continuance, and I'm not likely to grant that right now because this is now the 4th date that the parties have been back. This is the 3rd date that you've been here.
No.
Didn't you start on the 14th?
No.
Weren't you here on the 14th?
No.
Oh, no, you were not. This is the 2nd day you're here. I'm sorry. So which witness are you intending to call regarding the heat and air conditioning in the upstairs front bedroom?
I'm intending to call Mr. Branson and Ms. Collins.
Okay, well, I'm call him right now. They've been sworn in under oath.
Okay, but the problem is that I need time to deal with the exhibits. I still need a continuance, Your Honor. It's my 2nd time here. This is in less than a week. So I'm sorry that the plaintiff's procedural history is in whatever state it's in. However, again, whether, you've explained to me it's not a motion for summary disposition, but I can't emphasize enough that number 7 is just not true because it's not in compliance with local laws. That's what I was intending to discuss today. And of course, if we need to pull the evidence to talk about that, that's fine. But the problem is I still need to be able to give my client a fair trial. And I don't feel I can do that under these circumstances.
I don't want to say she's using some like sovereign citizen logic here, but it's the fact that she keeps changing the goalposts. Oh, I want to call witnesses. Yeah, exactly. The rumors are true. I want to call witnesses, just not now. You mean the people who are sworn in just in case they have to, give some sort of testimony? Those are the people you want to call, just not right now? Seems weird. Oh, the person you wanted to subpoena to be there for a witness, you didn't do it properly, so she didn't show up? That's weird. It's like, I understand you got to the party late and your damn client is an idiot, but it doesn't mean you have to follow along and be an idiot as well.
It would be different if I had been before you for a month, Your Honor. I would understand.
This portion regards applicable state and local health and safety laws. Okay? The ordinance that Mr. Branson may or may not be in compliance with based upon the certificate of compliance or certificate of occupancy is an ordinance, not necessarily something that falls under the health and safety laws. So the issues that we have to, so I think at this point, I'm going to dismiss the motion. I'm going to deny the motion to dismiss because the court doesn't find that the defendant was not being, or the plaintiff was not being truthful when he declared that the residential property was kept fit for the use intended, has been kept in reasonable repair. Reasonable repair doesn't mean 100% in repair during the term of the lease or license and is in compliance with applicable state and local health and safety laws. Okay, there hasn't been any condemnation notice put on the home. There hasn't been any other citations that Mr. Branson has received that would call into question the health and safety of the health and safety laws as relates to this property. Now, the other issues I indicated that I was going to address regarding the escrow, where the money goes, okay? Are you prepared for that?
No, I'm not. I was prepared to come here and discuss a motion to dismiss based on the fact that there's no certificate of compliance. You know, it's pretty straightforward in a lot of other circumstances.
What's pretty straightforward, counsel?
Like if you're in a locality and they check that there's no certificate of compliance, then it's illegal to rent the property. So the complaint has to be dismissed if it's for non-payment of rent. It has to be treated like someone's squatting. You have to issue a 30-day notice to quit. You have to proceed like this. You can't proceed, and she's paid, so there's
Where's the law that supports that?
Okay.
Where's the law that supports that if Mr. Branson does not have a certificate of occupancy or certificate of compliance, that the tenant then has to be treated as a squatter?
That's not what I mean, Your Honor. What I mean is she's been sued for non-payment of rent. She's all paid up in rent. But if there is an issue where there's not a certificate of compliance, you hold a different opinion, but I've stated over and over again that 7 cannot be complied with. That's why a lot of cities are putting into their ordinances specifically that these an eviction cannot be, a judgment of eviction cannot be issued against a defendant in these cases because of that.
But MCL 125.530 indicates an action can be maintained. So if the state law and the local ordinance are in conflict, which one prevails?
It's silent in the local ordinance, but it does say you cannot rent without a certificate of compliance. It's still an illegal occupancy.
So then that is an issue that Mr. Branson will have to deal with the city of Wyandotte if they choose to issue anything regarding him renting property without a certificate of compliance.
Right.
So how does that fall under violation of the health and safety law?
Crickets.
Okay.
Crickets.
I'm a little pulled in two different directions. 1 second.
Your Honor, while she's arguments, Your Honor, if it would.
Just one moment.
Thank you.
Yeah, random bloodleaf. It's because it's the only logical next step. Well, if the landlord isn't allowed to rent it, then you being there doesn't make you a renter or a tenant, it makes you a squatter. So like what's the next step of dealing with a squatter? That's the judge made that next logical step, just like I did 2 hours ago. But her attorney's like, oh, no, that doesn't make sense. It's like, that's what everybody else is thinking. You're just getting paid not to think that. You're getting paid to think anything else.
I guess I need clarification. Is it the court's contention that ordinances cannot be health and safety laws?
I didn't say that they could not be health and safety laws. What I'm asking is what is the authority that states that the ordinance, right, and not complying with the ordinance is a violation of the health and safety law? That is what I asked.
There's not an assumption when there's a law written to protect health and safety that that's what it's for.
You're telling me that a certificate of compliance is to protect health and safety?
Absolutely.
Okay, where's the connection for that?
Because a certificate of compliance, a city goes in and does an inspection. A certificate of compliance in this case in particular, because obviously you can have commercial ones, is for residential use. That's to make sure that the tenant is safe and it's up to city code. That is the point. It is absolutely to protect the health and safety. It's absolutely pertinent. It's a health and safety law.
Okay, the rumors are true. What attorney goes into a courtroom banking on one single motion? Let me make myself semi-large here for a second. So this is exactly a sovereign citizen argument. So it seems as if this attorney didn't just bank on one single motion. She banked on the fact that she read something and then stopped reading. She thought, this is good enough, this will get it dismissed. Instead of reading further about the other laws that could harm her argument, the other like exceptions to her argument. It's like the sovereign citizens reading a Supreme Court decision, getting to the part that they like, that helps their narrative, and then being done, even though the next sentence gives the exceptions. She didn't get to the exceptions. See, she read what she liked. She got the answer she liked on the phone and hung up, for lack of a better term.
Where is the law that states that the ordinances of a locality that addresses rental properties falls under the health and safety laws of the state of Michigan?
I would like a 5-minute recess to locate a case.
Okay.
Thank you.
We'll have a recess. We'll go off the record. I'm gonna have you go out into the lobby though, so my court officer can have a few minutes of the meeting.
How long's your honor?
Oh, yes.
Thank you.
I'm gonna following.
And again, if you watched this with Law Talk with Mike way earlier today, it's 3 hours and 55 minutes of not exactly an actual hearing. It's literally just them exiting, them talking for a few minutes, them exiting again, them talking for a few minutes, them exiting to look at phones and then coming back. Like the judge finally reappeared. A wild Judge DeSanto appeared. All right, here we go. We're almost done, folks. We're done. Kinda. Yeah, there is sound in the court. She's just muted. There we go. Back on the record with dipshit versus dipshit.
Up there at the front door, leaving Mark.
Okay. Consolation, I had just like had part of one of those muffins that are in the kitchen. So.
I wasn't hungry until I started smelling all
I
that
wasn't either. When I saw the muffin, I was like, oh no, it doesn't necessarily go with, I don't think there's much protein there, but. Okay, so. Okay, let's go back on the record in the matter of Ransom versus Collins. 2402269, an appearance for the plaintiff again, please.
Good morning, good afternoon, Your Honor. Amy DeCray on behalf of the plaintiff, Mr. Branson.
Okay, thank you.
I'll leave that likewise, Your Honor.
Okay, Mr. Branson.
William Branson, Your Honor.
Thank you, counsel.
Good afternoon. This is Megan Buckle on behalf of the defendant.
Okay, thank you. Okay, and just so you know, there is an individual sitting in the court. She had scheduled a meeting to meet with me on some mental health something or other, I think, as part of her research class. She's on mock trial team in the 33rd District Court, so she's not here at any point regarding anything with this case. I just wanted to state that on the record. Okay. All right. So, counsel, I did give you an opportunity to want to look up some case law.
Thank you for that. I clearly need to brush up on what I learned in law school. It's the Home Rule City Act. So under the Home Rule City Act, and that's the State of Michigan Act, section 117.3 under mandatory charter provisions.
I'm sorry, it's MCL 117.3?
No, that's the section. Let me look up what the Home Rule City Act citation actually is. Okay, so it is.
She's basically at this point playing attorney by Google. That's what she's doing. Anytime she runs into a wall, hold on, Judge. Can I go out to the hallway and Google something? That's what she's doing.
MCL, no, that is correct. It's 117.3. And under the act, if you go under 117.3 and go down to section J, it states the public peace and health and for the safety of persons and property. In providing for the public peace, health, and safety, a city may expend funds or enter into contracts with a private organization, the federal or state government, a county, village, or township, or another city for services considered necessary by the legislative body. Public peace, health, and safety services may include the operation of child guidance and community. Okay, it kind of goes on. It's contextual. The purpose of this act, Your Honor, is to state that the body corporate, which would be the city in this case, they are allowed to enact laws in the form of ordinances that protect the public peace, health, safety, and welfare, and carry out the enforcement of that. Now, in terms of a case, I can give you the federal site, or would you like the Michigan citation? Does it matter?
Well, hold on a moment. So before we get to the case, which the case is going to indicate how the laws apply, you're relying on MCL 117.3 to be the prevailing statute as to show that the...
Okay, I hate to break into it, but if you notice the, let's just call this the defense table over here, right there. It looks as if the defense attorney that he had last hearing is just over there playing Candy Crush. He like, tag, you're it. And she's just doing it all. Gotta sneeze.
Not having the proper rental certificate is a violation of the health and safety laws.
Correct. This is an enabling statute. So it's a specific directive by the state of Michigan that what the city is doing is it's enacting laws that are for the purpose of health, safety, and welfare of its citizens, and they're responsible for enforcing those laws as well.
Okay, so under J, which is what you referenced, the public peace and health and for the safety of persons and property, in providing, well, actually, it talks about each city charter shall provide for all of the following. And J is the public peace and health and for the safety of persons and property. Is it, what's your phone doing?
They were on for the text messages.
No, there's only one that should be on, not they. Only one should be on because only one is what we've been using for text
I text
messages.
messaged my boss to let her know I'm still not coming in yet.
Okay.
I had to work today.
Let me see here. Stacy Mew. Isn't there a chicken breed named Wyandotte? Funny story. We actually covered a guy, me and KTZ, a body cam of a guy from Wyandotte who was calling his neighbor Dan the Chicken Man and just kept making chicken sounds at him while he was standing in the road. So there's Dan the Chicken Man. I don't know if that's a breed from Wyandotte.
You turned it off?
Yeah, I just turned it on.
Subsection.
So, hold on, Council. The public peace and health and for the safety of persons and property providing for the public peace, health, and safety. A city may expend funds or enter into contracts with a private organization, federal or state government, county, village, or township, or another city for services considered necessary by the legislative body. Public peace, health, and safety services may include the operation of child guidance and community mental health clinics, the prevention, counseling, and treatment of developmental disabilities, the prevention of drug abuse, and the counseling and treatment of drug abusers. I'm not seeing anything in here how certifying rental homes falls under health and safety.
Absolutely, Your Honor. There's actually several mentions of health and safety and welfare within this statute. That is merely the first. One moment, please. But the case is certainly informative.
Your Honor, may I make a statutory construction argument?
Just one moment.
Thank you.
Okay. If you go down to section 117.35, it does reference the health and safety of persons living adjacent to land that's been condemned.
Okay, hold on. 0.35?
Yes. And then I'd like to direct the court's attention to the case.
Okay, what's the name of the case? Well, I'm trying to get to 0.35, what's the name of the case?
It's called Sabab versus City of Dearborn.
Okay, SABBAGH, AUGH?
Yep,
Okay, is this a published opinion?
it is.
Okay, what's the citation, please?
384-510, 1971.
Okay.
Random Bloodleaf, I forgot what the was it Sun Tzu or something? I'm gonna just butcher this, but it was like, if you see your enemy making a mistake, just let them or just say nothing. I feel like that's what the plaintiff's lawyer is doing. She's like, oh, this attorney's digging herself a hole and I don't have to do anything. Good luck and I'll see you when you get done.
So this case is actually particular.
Before I get to the case, I'm going to give Attorney Amy an opportunity to respond to the statutory portion.
Thank you, Your Honor. While I don't disagree with Sister Counsel that this is an enabling statute, this statute was intended by the state of Michigan to allow for the division of large pieces of parcels of land to become cities, states, or cities, townships, counties, and things like that. And it is a provision that allows them to enact statutes or to enact ordinances and codes, and then thereby enforce their codes in manners that include, you know, spending money to do it, and also to engage in contracts. But you're absolutely right on point when you pointed out to Sister Counsel that nothing in this statute indicates that this specific ordinance was enacted by this municipality, a quasi-legislative body, because a municipal ordinance is enacted by a quasi-legislative body, quasi-legislative body was intended to be for the general welfare. So this statute says, yes, cities can do these things. They have the ability to organize themselves and to create a government and to run their government and to collect and expend funds for the running of their government. But nothing in this statute is relatively on point to determine whether or not the CFO statute or ordinance is from is part of a health and safety or health and welfare was enacted for health and welfare purposes. And moreover, what you said earlier is actually right on point. When you question Sister Counsel about the interplay between the powers that be here, the state ordinance, which we know is, which we've cited many, many times as 125.530, and the city ordinance. When there's an interplay between a state ordinance that's directly on point in something, the municipality is not at will. And when Sister Counsel talks about this case, it's actually proven in this case that the city is not at will to abrogate that statute. The statute set forth the remedy. The statute did not set a private right in the defendant or in a tenant in this case. So while this statute said, yes, the municipality can do that, nothing in this statute says that that's what this municipality did, or that specific ordinance, the CFO ordinance, falls within the scope of health and safety of this community, Your Honor.
Okay. So just one moment.
Your Honor, I'm sorry if you're sick of hearing it, but I'm not sure how much longer we have to go. I again need to request a continuance. I wasn't anticipating being on the 5th hour, after it was scheduled. That's all. That's the reason. And I have other important business matters that I'm missing.
Okay, Counsel, when we scheduled this date, nobody said anything about having any time limitations, or else I would have addressed that at that time.
I didn't think it was reasonable that this would be this long.
So are you stating that it's unreasonable that it's going this long?
Frankly, with the situation in terms of the clear violation where cities are responsible for the public safety, health, and welfare, and that involves having proper licensure to collect rent under a lease agreement in a residential property, yes, I think that it should again be dismissed on that basis.
Okay, Counsel, you're making many leaps without having any connections to get you to the other side. Because even under the Michigan Occupational Safety and Health Act, Act 154 of 1974, which is in the chapter 408 chapters, I have yet to see anything that would tell this court that a rental certificate falls under the Safety and Health Act, whether it's the Occupational Safety and Health Act, whether it's any health act, anything, any of the chapters within the statutes. I have not seen that connection. I understand your thought process that because a house may not have a rental certificate, that there in and of itself is enough to say that there's a violation of health and safety laws. There's not a connection for that, to show that. The issue regarding whether or not Mr. Branson had a valid rental certificate is an issue that he's going to have to address with the city of Wyandotte if they so choose to pursue that. As it relates to your client and her obligation to pay rent without having a valid certificate of rental, your client isn't even allowed to withhold rent without depositing it into an escrow account. So clearly there is a lot of consideration for these types of situations because there's an entire statute on it in MCL 125.530. And nothing in here indicates that this would rise to the level of violating health and safety law, okay? Clearly, municipalities want to make sure that there are any homes that are being rented or anything of that nature, any buildings being rented for multiple purposes, right? They want to make sure that businesses are properly registered. They want to make sure that rental homes are properly registered. They want to make sure they know who owns what property. They want to make sure that if somebody is renting something that things are up to code or what have you, okay? So that doesn't necessarily mean that falls under health and safety law, because I haven't even seen anything in the statutes, because these rental certificates, I believe, are good for 5 years. So within those 5 years, there's not re-inspections to make sure that the homes are still habitable and still complying with health and safety laws. So I don't find that not having a certificate of rental, a rental certificate, falls under the health and safety laws. So you can respectfully disagree with me, and you say that you disagree with me, you don't find that it's reasonable, and that's your prerogative, counsel. If you feel as though I've gotten it wrong, you can certainly file an appeal. But this court does not find that there is a basis to dismiss this action on pursuant to paragraph 7. Because paragraph 7 states that the home has to be kept that has been kept fit for the use intended, which there hasn't been any testimony that's been not kept for use intended, which was a rental property, which is why the allegation that he doesn't have a rental certificate has been at the forefront, has been kept in reasonable repair during the term of the lease. Okay, I've heard some mention regarding an outlet, possible mold, but there's not anything that was put forth prior to this matter having already occurred. And it says reasonable repair. Doesn't say 100% compliant without any repairs needed. And the court, and it also says it is in compliance with the applicable state and local health and safety laws. So this court's interpretation of that provision is the home has not been condemned. There have not been repeated citations issued to Mr. Branson regarding violation of any of the codes or property maintenance or anything of that nature. So for those reasons, I find that the home is in compliance with applicable state and local health and safety laws as far as that goes. Mr. Branson will have to deal with the city of Wyandotte if they so choose to proceed. However, if they do, with not having a rental certificate while he was renting the property and collecting rent. The court will also note that Mr. Branson, there's a check that was written at the beginning of November for an inspection. So we're talking, you moved in the month of June. About a little over 5 months of not having a rental certificate, not having a pending one or whatever prior to requesting an inspection. Now, I don't know what's happened with any of those communications. I'm not sure about any of that. But what was submitted in the exhibit that I reviewed last night was that there was an email and a receipt, or not an, I think, oh, there was a receipt. And I think that there's also a letter included in one of these exhibits regarding that request. So I'm denying the motion to dismiss. I'm not denying your client or yourself, counsel, a fair opportunity to present evidence. I do not find a connection with the ordinance requiring a rental certificate to fall under state and local health and safety laws. So that's the ruling of the court regarding the dismissal. Motion to dismiss. So that's denied. I don't believe that there's any specific testimony that would alter this court's ruling as it relates to the motion to dismiss, because in this court's opinion, it's a legal analysis as to whether or not the property is in compliance with applicable state and local health and safety laws. But I went through the exhibits that were put forth and the issues that your client raised in her written motion regarding the flooding and the bugs, because that could potentially rise to that level. But based upon the testimony that I heard and the review of the messages that I reviewed, that does not seem to be the case. It appears as though Mr. Branson, when something was brought to his attention, treated it as it needed to be treated, or responded as it needed to be responded to. Now, as it relates to the issue of the June rent, let me do this. We have the June rent. We also have the security deposit, because I believe that your client, which I didn't specify this previously, I didn't make a note of it, but I recall that your client, that there was discussion regarding the security deposit, which I think, as we all know, we can't do anything with that until after Ms. Collins moves out to determine what. I'm sorry, what?
I'm gonna stay until the end of my lease.
No, that is not what this court ordered.
This is, if you're gonna say that this is habitable and I've been paying my rent the entire time.
First of all, you just interrupted the court as I'm talking. But as I was saying.
Okay, so what just happened was she got super tired of her attorney losing the case, and she thought to herself, I can do better. So she just decided to interrupt the court and say, fuck it.
The court, as we all know, we cannot make a determination regarding the security deposit until after Ms. Collins relocates to see if there's any deductions or what have you. Now, Ms. Collins, you stated yourself that you were moving out. You did not want to stay there.
No.
You did. You stated that on February 7th or 14th.
No. You took my words and you twisted them, Your Honor.
I did,
Yes, yes, you did.
Okay, so what is it you said, ma'am?
Your Honor, this right now is the only place I can stay.
No,
Right now, I just found out my cancer
That's
is
not what you
bad.
said. No, that's not what you said. What is it you said?
I am 100% paid up to rent. This is an eviction. If I did not pay my rent,
Ma'am.
I was gonna have to leave. I'm
Ma'am.
staying until my lease is up.
Ma'am,
I
What is
appeal
it?
this.
excuse me.
I'm appealing this.
What is it that you said?
Then I'm gonna stay here.
No.
Yes, I did. I said that day that if you're gonna make me, if you're gonna make me pay, I was going to stay. That's exactly what I said that day.
I asked you if you.
That's exactly what I said.
I asked you if you wanted to keep living there. You said, no, you don't. You said, I will gladly move out.
No, I did not.
Yes, you did,
No, I
because
did
then
not.
we got onto the discussion as to the escrow money and who gets the escrow money. Because
Just to confirm, to throw my hat in with the judge on this one, I started talking about this at the very beginning of this whole hearing. Oh, you can see where he was eating the kneecap, and he's just eating it everywhere in my office. I'm going to have to clean my whole floor. Dear Lord, maybe cow kneecaps were a bad call. But I started talking about this when we started watching, about how she was talking about her wanting to leave, but didn't have money. So they were trying to say, hey, how much money do you need to move? And now she's trying to backtrack and be like, oh, I never said that. And it's like, I have the recording. Colin has the recording. Old Squishy Gardner has the recording. Lone Wolf probably has the recording. Law Talk with Mike probably has the recording. It's like, ma'am, there are plenty of copies proving that you just said that.
Because you said that I need my money back so I can go find a place to live. That is how that conversation went. So, the other issue that we have to address is the escrow money. Any other issues that we need to address?
Not at this time for a opinion, Your Honor.
Are there any other issues that we need to address, council?
No.
Just those issues?
Yes.
The June rent, oh no, the utilities, we have utilities that we have to address.
Your Honor, is there any way we could resume at another time with the rest
Yes,
of this?
I'm going to pick another day, I just want to make sure we're all on the same
I'm
page.
just trying to get somewhere. Okay, yes, the utilities.
Okay, anything else?
I don't think so.
I need time again to figure things out.
Yeah, I'm not telling you have to leave tomorrow.
Thank you.
I'm not saying that at all. Because I also recall that you say that you've been looking for places to move. So to tell me that I took your words and twisted them, ma'am, is not accurate. Okay?
Your Honor, I think you also requested that she provide to you the names and addresses and phone numbers of the people that was contacted.
I will not get that to the court.
I did.
Gregory, the defendant, needs to be put in jail for a month for contempt. It actually gets worse.
I did request that, ma'am, because you stated that you needed a certain amount of money to move out. So I was trying to facilitate some sort of resolution between the parties. That is why I asked you for a list of where and the cost that it would take for you to move there.
I'm looking at the cost right now, it's roughly between $4,000 to $5,000, so.
Okay, that's why I asked you for something in writing to present to the court. Because I have some credibility concerns based upon what's been presented to me and only wanting to give me partial information.
It cost me $5,000 to move here, into this place.
So I did ask for you to submit that information to the court as well.
I will have that next time in front of you, Your Honor. I thought it was unsafe because on YouTube I've been harassed.
What?
With your YouTube, I've been getting.
Let's back up for a second. Here comes another sob story from her. Apparently, this is all YouTube's fault now. It's all YouTube's fault.
Information to the court as well.
I will have that next time in front of you, Your Honor. I thought it was unsafe because on YouTube I've been harassed.
What?
With your YouTube, I've been getting emails, I've been getting text messages because you put all my information out there.
I don't put your information out there, ma'am. Okay, so we live stream, right? Courts are live
I
streaming.
did not know that at that time.
Ma'am, it's posted all over. The sign's there. There's a sign out in the lobby. There's a sign on our website. There's plenty of notice that we live stream. We do not, and then we take it down after each of the
And I would
each of the
never
days.
put my email to you. I would never give you my email. I would ask you to do that in private. I would never give it to you.
I don't remember giving me your email.
You had me give it to you. And you also had me give you my place of employment. And I would have never given you either of those. I would have never given you those on.
Okay, I don't recall having you provide your email address.
Yes, you did.
Zoom.
Okay, just for future notice, if somebody does give their phone number or their email, don't contact them. Just don't. And she's giving you a shout out, man. Nothing beats the time Broken System, Broken Trust used my actual name and channel name in court with Judge Slavin. So I did get an actual shout out from BSBT in court. He also shouted out Artie's Corporate Fiction. If you guys aren't subscribed to Artie, go subscribe to Artie. He is a lawyer, but he's not your lawyer. But yeah, this is shout out to everyone who court watches.
But, okay, and I apologize if I did, I don't recall that.
And getting harassed many times at work.
At work?
Work and in my email, yes.
Okay.
Because of that.
Okay, well, ma'am, I am unsure how to rectify that issue. I mean, I would hope that people wouldn't be contacting you. It's not appropriate, in my opinion. So, we're going to have everybody return, we're gonna pick a date. These are the issues that we are going to address. Everybody, I'm expecting to be prepared. I'm also expecting that there is going to be productive communication, conversation, exchange of information, whole information between council. And Ms. Deklala, I did, and Ms. Council Amy and Mr. Dagger, I did review all of the communications that the court was CC'd on regarding the request for utilities, the refusal to speak to Ms. Kennedy, or respond to Ms. Kennedy because it's unauthorized practice of law. Counsel, she is a paralegal, apparently under the supervision of the attorneys, so there can be communication with that. So Ms. Kennedy, I apologize that we messed up your vacation day today and we haven't needed the body cam video. I don't know if we'll need it next time. I guess just have it ready to go in the event that we have to talk about it. I don't know. But the court is, let's pick the date.
Your Honor?
Yes.
I was attempting to discuss the utilities issue with Ms. Kennedy outside as per your directive last time.
Okay.
And she would not go talk to Mr. Ali Dagger about what I was saying. That's why I said I needed to speak with him. She would not go and communicate what I was speaking.
I'm talking about the email that went.
Right, but it's just a little bit harassing to me, honestly. That's the problem.
Your Honor, the real issue is that there was an email sent out where we asked Ms. Deklala for information. It was that email. Ms. Kennedy followed up and said, hey, we needed these things from you. Ms. Deklala responded to that email with abject vitriol towards Ms. Kennedy, telling her that she's like, go get your boss. Like, you're not practiced to law. And then I responded. And
Right,
I said,
I reviewed all of
yeah,
this,
and
yes.
I need this information. And she told me, go get Ali. Like,
I didn't know who you were.
I had a notice of appearance on file, ma'am.
Okay, well, I hadn't seen it.
You were emailed it to my men.
Please stop.
You were emailed my.
I'm exhibiting respect.
Okay, she's indicated
I
that
just
she
want it
sent
to
you.
stop. I just want to focus, I'm sorry. I just want to focus on the issues in the case.
Okay, but I will also say, if there's this much emotion between counsel, it's going to be hard to focus on the facts of the case and the resolution of the case.
Judge, the bottom line is that we just need what she promised, and that is the evidence to support whatever allegation of overpayment of utilities. It's that simple. And we've been trying since the last time we were in court to obtain that information without any success. I would like the court to designate a specific time where that information can be exchanged. We have provided all of our documentation related to utilities, but we haven't received anything that would evidence any type of offset.
Okay,
Could we set a time?
so, counsel, is there anything in the information that you and your client have regarding the utilities? Because I believe your client indicated she's overpaid utilities and she is entitled to a credit.
Why can we not engage in discovery requests between us?
It's a summary proceedings,
You
you know?
know, well, I don't know that I don't know that discovery rules specifically apply, but the court's ordering the parties to exchange information as it relates to utilities. So if your client's indicating that she's overpaid, you can turn your phone off now, ma'am. We don't need any more text messages, so you can turn your phone off.
Looking for dates that we're gonna go to court.
Okay, okay. So your client has receipts of payments, or what is it that she has that she's indicating supports her claim for overpayment of utilities?
So she has been paying via Zelle,
Okay,
an overall rental amount, I suppose. Because her landlord, the plaintiff here, texts her and tells her how much utility she has to pay.
okay. So here's what I need. Here's what I need. I'm gonna spell it right out. I need from both parties text message communications regarding every utility bill that has been communicated, okay? That's the first thing I need. Then I need, if all the payments are via Zelle, I need proof from your bank, the bank statements that show the Zelle. You can even print up the Zelle, whatever it is, as to where it goes. Show the deduction out of your bank. Mr. Branson will show that it was deposited into his bank, okay? So, Anything else that we would need, statements, we need the utility statements, that'd be Mr. Branson would have.
They've been provided with those, Your Honor.
I'm not saying they have, I'm saying what I need to make a determination on the utilities. Okay, so that is what I need as it relates to utilities. Okay,
Thank you, Joe. When do you want us to come back here? I know, we're all excited.
March 14th. March 14th at 10 a.m.
Thank you for that.
The escrow will continue, Your Honor?
Yes, March 14th at 10 a.m. Does everybody,
Yes.
That's fine.
Thank you for giving me that.
Which day is that on?
it's a Friday.
Your Honor, I work on Fridays.
Ma'am, I can appreciate that, but we have to get this matter resolved. I'm trying to give enough time so that there can be the information, excuse me. I'm trying to give enough time for the information to be retrieved and exchanged.
Yes, Your Honor.
And enough time, if there's any witnesses that need to be subpoenaed, to be subpoenaed.
Yes, Your Honor.
Thank you so much.
Thank you.
So, I would plan to be here for a number of hours,
Okay.
okay?
Yes.
I don't know how many hours that is, but I plan to be here for a number of hours,
Thank you, Your Honor.
okay?
Thank you.
All right, thank you.
Thank you, Your Honor.
Thank you. Oh, I'm sorry, hold on. The court did receive another order for inspection. And, counsel, I'm going to have you both look at it quickly, just so you can see what it is that the court's signing and that the provision regarding the third-party interference with automatic show causes, that was removed.
Section 6, between 9 and 2. Inspectors of the city of Wayne. Full cooperation of defendant.
Who else?
Just the inspector.
Nobody else, just the inspector.
Yeah.
And me.
Yes.
Mr. Branson will not be there.
That doesn't say
Well,
that.
I don't know if Mr. Branson is required. I don't know.
I will be there.
I would presume Mr. Branson would have to be there because he's the owner of the home.
Yes, ma'am.
And we did go over this last time.
I don't want police in my house.
Excuse me, we did go over this last time regarding whether or not, Mr. Branson was able to be there, or if you had to be there. And the determination after reviewing the statute is that you don't have to be there, but Mr. Branson has to be there. You obviously have the right to be there, but I'm stating that Mr. Branson would have to be there, he's the owner of the property.
I will not allow police in my property though this time, after what happened last time. I'm putting that on the record.
I don't know what happened last time, I don't know what happened last time, I haven't.
Oh, you should see the video.
They asked for my escrow account. They said that I'm in landlord tenant court and they didn't believe what was going on.
I'm
It was a joke.
sorry, but we have another hearing. I really have to go.
Counsel, I understand, hold on a minute, Miss,
If you guys were watching the last hearing, I believe it was, they actually tried to put into the record, they emailed it to the judge, the police body cam footage. And I'm hoping they show it eventually, because apparently it's really good. But the police telling you to wait outside because you're a fucking nut job, it tracks with what we've seen in court from her.
Ms. Collins, just a moment. Counsel, I understand that, but I'm also trying to prevent what I can foresee happening on Tuesday, Wednesday. What did we say, the 26th?
That's 26, Your Honor.
That's Wednesday.
I would like for, if necessary, for the police to be there.
No.
I think the main thing.
No.
Please.
I was
Hold on.
pushed aside and told I could not go into any room.
Absolutely not.
I have it on my security cameras as well. I was pushed aside and told I couldn't go into any rooms because I was in landlord tenant court. I had to show them my escrow papers or they weren't gonna believe me.
Absolutely not.
Okay,
Not anything
okay.
that you asked for to happen.
What?
Not anything that you asked for to happen. I said, no, he's supposed to take pictures that I want to. They said, this is a
No,
joke.
no. I did not state, but counsel, you don't have to point at me.
No, I'm sorry, I apologize.
I did not say only the pictures that you want. That is not what I said.
No, I know that.
What I said was that Mr. Branson was to take pictures of the areas that you were stating were of concern. That didn't prohibit him, that didn't prohibit him from taking photos of other areas of concern that he had, okay? And that was specifically brought up on the record.
He wouldn't do that. He wouldn't take any pictures I asked him to. And they said they weren't gonna make him.
Ma'am,
It was a joke, and I don't want police in my house.
ma'am, let me just say this, okay? I cannot predict the future. I cannot predict behavior. What I will say is if a city inspector feels the need to contact the police because there may be a disturbance or there may be some concern
I would
or
be
other,
very nice, but they're not.
excuse me, please stop interrupting me and we're not done.
Heather.
We're not done. Please come back up here. I cannot tell the city inspector they cannot call the police. Okay? I cannot tell them that. So what I'm saying is,
He's gonna call them, they won't.
ma'am, Mr. Branson, I cannot, here's what I'm going to say. There's not a need for civil standby during the inspection. There's going to be an independent person there, the inspector, and I expect everybody to be on their most adult, appropriate behavior for the entirety of the inspection. That means not communicating in the ear of the inspector as to what they need to look at or anything of that nature, okay? The inspector knows what their job is that they have when they arrive at the home. There should not be any videotaping. There should not be any video recording. There should not be any audio recording. There should not be any communication at all, other than, hi, how you doing? Welcome to my home, whatever, something simple like that. That is it.
I promise you that, Your Honor, except for my security cameras, correct? Our security cameras that are there.
I don't know what your security cameras, would they go on when people walk in? I don't know what that is.
Okay.
I don't know what that is.
I promise I'll be exactly civil this time, 100%.
If the city inspector feels the need to contact the police for whatever reason, that is their right. That is their prerogative, okay? That is what I'm saying. I'm not prohibiting a third party who's not under the jurisdiction of this court from contacting the police.
Thank you.
Thank you so much.
Thank you. Have a good weekend. We'll see you back on the 14th at 10 a.m.
Sounds good.
Did you hear what you just said?
Wait, hold on. Please come back.
Please come back.
Her attorney is just waiting to leave. Coat on, like she's counting down the time to leave school. She's ready to go.
Mr. Gander, what is it you just stated to my court officer?
As I stated, Your Honor, as she was leaving, she called
Who's
me,
she?
Miss Collins called me a name. Asshole.
I did not. I swear I did not. 100% I did not.
Well, ma'am, you flipped him off last week.
Okay, so you're gonna believe everything he has to say?
Ma'am, I said you flipped him off last week.
Okay, and I admitted to it, did I not?
You admitted to it.
Yes,
Okay.
and I'm not admitting to this. And I admitted to things I said in the hall. I'm not gonna admit to something I didn't do. I admit to things I do.
Okay, so I'm gonna have Ms. Collins and Ms. DeQuala for you to please leave.
Thank
Not
you.
saying anything. Thank you, Ms. County. I'm very sorry about your vacation.
She's on the beach road. She's fine.
You see her name is on her camera off, so that someone did not have to languish behind with her beautiful screen.
This is not normal how it works.
Thank you.
Thank you.
Thank you, I appreciate it.
Now the judge is sitting there
Thank you, Judge.
thinking, what the fuck was that?
You're welcome. When you guys go out there, she's standing right there.
All right, so that's where she mutes it. That's all we got today, folks. Oh, dear God. So remember the rules for next time. Super chats, memberships, dog gets a bone or a kneecap. There we go. Come back to me, camera. I might have Bella in here next time. Might have Benson in here next time. I know you guys saw Benson for like 5 seconds the other day. That's the new puppy, but yeah. That's it. Yeah, like I said, it only got worse. She freaked out on him in the hallway last time. She flipped him off in court last time. She already walked away from the conversation today. Now she called him an asshole. Even though he didn't do anything the entire case except for the end. That was it. I say we take bets on if she gets a contempt charge before it's all over. That's probably how it's going to end, honestly. they're going to side against her. She's not going to like it. She's going to say, I'm going to appeal this. I'm going to sue you. I'm going to get you fired. And then contempt. Good old sovereign citizen style. But yes, I will get to working on a video for tomorrow because I plan on laying floor in a bathroom tomorrow or painting the rest of my kitchen tomorrow. Either way, some of you guys might get pictures of that when it's done. You know who you are. Everybody have a good rest of your day. Be safe. Don't email. Don't text. Don't send this chick a letter Blues Clues style. Leave her alone. Not even Mark can fix her. But yeah, everybody have a good rest of your day. Bye.